Monday. Monday. Seven. When did you file it? Filing it today. Why should we call for it now? Let it come some other day. Why have you filed an affidavit today? See, wait for it. Readings like that when the matters are listed. When did you file it? Not the way to do that. What vital document? What is that vital document? Transfer order. The new transfer order, new course of action. Uh, when did they file? 18. 18. Take it from Section 32 of the request. 2930. Yes, 26. 2930. They take the benefit. 3 stands different. Filing objection. File the objection will file, you make a matter. Sixth of April. Yes. Twenty-eighth will be made by Let the affidavit be filed. After that, you make a motion. Can't hear you. 34. The petitioner respondent. 34 stands deferred on the request made by the counsel. They're seeking adjournment for what purpose? Once you file a rejoinder, you make a mention. Yes. I can. Which was mentioned. All right. Item. Respondent. Then defer the request made by the counsel. Adjournment. Time on the request. For seeking for listing for orders. Matter. Matter. It will come in April. Of April. 6th of April. Right.
May I please, my lord? Lord, I am appearing in this matter on behalf
Yes,
of.
we can hear you now. Yes.
Sorry, my lord. My lord, it's a Section 11 petition, my lord. The arbitration clause is directly hit by the apex court judgment of core, my lord. If my lord may just have one page, the clause itself.
Page number
160.
160.
64.3.b. Roman 2, my lord.
Yes.
In the case where the total value of all the claims in the quotient added together exceed 50 lakh rupees, the arbitral tribunal shall consist of a panel of three railway retired or retired not below rank of senior officer as the arbitrator. For this purpose, the railway will send a list of panel. My lord, this clause, my lord, is today held illegal by the court, my lord. So that is my request, my lord. The clause is
You have
there.
not given a waiver.
My lord, I have not given a waiver. That letter is also there, my lord.
Yes. Where is your notice?
My lord, I'll just invocation notice, my lord. is at page number 351, annexure 35. And then, my lord, 358, when they asked a waiver, we refused. Annexure 37.
That you requested for an arbitration panel.
My lord,
Page
that was
353.
yes, my lord. My client was not. He sent it himself. After that, my lord, there is a waiver. They asked them. They
Page
asked a
number.
waiver.
Page
My lord,
number.
page 358 is my refusal to the waiver. And 356 is their letter asking for waiver.
Railways, anything? Notice? Heard. Mr. J. Sehgal,
Jatin Sehgal.
counsel for the petitioner.
Lord, can I make one more request, my lord, if my lord may
Yes.
permit me?
Yes.
My lord, there are 7 more arbitrations between the same parties with regard to the similar kind of contract, my lord. I have a list. We have already filed section 9, which is pending, my lord. Invocation done. My lord, technically, my lord, in all the matters, my lord, the clause are same, parties are same, the contract is same. Yes, my lord, we have not come to the stage of section 11 in those cases yet because we are following the conciliation mechanism, but all these clauses are hit in the same section, my lord. If my learned friend can take instruction, because we are already contesting section 9, my lord can appoint a common arbitrator in all the matters also, my lord. That is my request.
Matters will have to be before the court.
Please, my lord, I was only saying that if they can take a consent, my lord, then
That is
probably.
between you and the railways. You sort
Please,
it
my lord.
out.
Please, my lord.
If they are agreeable to appoint an arbitrator as per your request, then it's all right.
Yes. Please, my lord. Then my lord may appoint in
But
this.
otherwise, if the court has to appoint, then you must be before the
Yes.
court by
Yes, my lord.
way of a proper proceeding.
I agree, my lord.
Third counsel for the petition. By section 11(6) of the Arbitration Act. By the railways. When they do agreement. Did you complete the contract or was it terminated?
My lord, terminated, my lord. I am saying that I was not given the site, my lord. That is why it was terminated.
So, but there was an agreement executed.
Yes, yes.
Pursuant to the agreement, according to the petitioner, the site was not handed over in terms of the agreement. Therefore, work not proceed. Consequently, the contract stood terminated by the railways. Stop. Despite all efforts being made to sort out the differences, same has not been sorted out. And therefore, railways. Select name of the arbitrator from the panel which was not consented to by the petitioner. So as a consequence thereof, petitioner has approached this court in section 11(6). C represents all the respondents. All the respondents. Therefore, notice is waived. Extra copies are furnished within a period of 1 week. This again after the returnable date.
I am grateful, my lord.
From a discharge from service on the ground of plural marriage. There was an earlier round of litigation also where vis-a-vis other cases that were considered, my case was also directed to be considered. We are against that particular rejection order as of now.
Where is the rejection order?
Rejection order, my lord, Annexure 21. Page 102. Sir, my lord, there was a plural marriage, but then the mitigating circumstances surrounding that, and the fact that actually subsequently, though
What mitigating circumstances?
that the wife had deserted him, my lord, and she had no objection if he had second marriage. They were under a mistaken impression of law that divorce is pending, formal divorce was pending, and there was a certificate, my lord, given to that extent that yes, they are separated. Based on that, he conducted the second marriage and himself reported that to the authorities. That is how the authorities came to know that he had conducted the second marriage. Subsequently, my lord, he has been formally divorced also. Page 58 is the.
Where is the order? Page 10?
102, my lord.
10. What was the?
He emphasized on Rule 10 too, my lord, if you are looking to 104.
Where is the dismissal order?
Dismissal order, my lord, Annexure 15.
You are not challenging the dismissal order.
We are praying also for conversion that the dismissal should be converted to charge. Then only I will be entitled.
The challenge effectively is the dismissal order.
My lord.
Page number?
Except the I think basically, my lord, because there are two children, my lord. So I have to take another one. Any benefit, my lord, it's very difficult.
It mentions that you are entitled to get pension.
My lord, we initially said so, but then ultimately the law is that if it is a dismissal order, there is no pension.
Yes, who's for the respondent? Yes, that counsel for parties, we should move this to the 4 weeks. Yes, Borwa doesn't come. Leonard CC. On behalf of extra copies furnished to the one. Respondents will complete their instructions and file necessary evidence.
Yeah, please, minute. What I read, but cannot under record.
You have filed some IA.
Yes, fine.
Ah,
But then observe, sir,
ah.
the prior portion.
Any objection? Heard counsel for parties in time will be IA. So IA has been filed seeking amendment of the writ petition
Or
in the,
3.5.
as indicated in para 5 of the IA. Mr. P. Chakraborty, learner, CGC, appearing for the respondent, does not object to impairment. I extend the law. Petitioner is permitted to make necessary amendment and file the amended writ petition with the registry, as also serve sufficient copies to be responded. So matter be said thereof.
That is also pending another for country passport.
What item?
Item 54. Appeared for the interview for the post of Anganwadi worker in North Dotma Anganwadi Center, my lord. But my lord, the selection committee had selected respondent number 8, my lord. And select list dated 3/1/2025, page 40 to 42. As I have filed my lord RTI, then I have received this my lord select list, my lord.
You were at serial number?
At serial number, my lord, page 40 to 42, my lord.
Yes, 42.
Yes, my lord.
Serial number?
I am serial number 2, my lord, but as my lord remarked, my lord, they have referred that I was a student, my lord. But I have made a statement in my petition, my lord, as I am my economic weak, my lord, so I have not continued my further studies, my lord.
Get instructions. This will not issue. Issue notice. Can't get instructions without notice. Right, direct counsel. Here's an exception of this one. Therefore, sorry, MSS Borua for 1 and 2, Strawberry for 5, 6, 7. It's after the internal.
Obliged.
My lord, here earlier that the approach is honorable court, and it was though the lordship will find page 61. Liberty has been given. Page 61, second paragraph. That an order, speaking order has been passed on 3/6/25, visiting the claim of the petitioner. So the petitioner has been given liberty to challenge this order. Now the entire matter is that is a compensatory appointment, my lord. District level committee has selected the petitioner. Their process has been started. Your lordship will page 33. The death of father of the petitioner, the petitioner is Ganesh Kanan, madam, serial number 1. So here the district level committee has, my lord, selected the petitioner as a
He's the petitioner. No, who's the petitioner? He's the petitioner's father.
The Ganesh Kanan is the petitioner.
He's the petitioner.
Yes, my lord. So he has been selected, my lord, in the grade 4 chainman.
This is by in the DLC.
DLC, my lord. Then, my lord, what the Joint Secretary of Revenue Department has taken process. It is annexure H page 48. You'll also find a column serial number 7. In the middle part, Sri Ganesh Kanon, vacancy position and cadre strength. That is written to the Deputy Commissioner Hemaji. So, my lord, by next annex, that is page 50, annexure I, the Deputy Commissioner Hemaji has informed. In reference to the I have the honor to inform you that there are 20 numbers of original pension posts of chainmen under the amalgamated issue of the Hemaji, out of which 2 numbers of posts are lying vacant. For performance of revenue works promptly and urgently, it is required to build up duly ill performance and close herewith of your kind information necessary action. So page 51A, my lord, the statement. So, my lord, the matter was processed.
What happened before the SLC?
Yes, now, my lord, that SLC, in the meantime, the SLC has, my lord, come in play. That is your lordship will find at page 45, decision of SLC. There's last but the bottom, my lord, 3. Office of the Deputy on Dhemaji, Sri Ganesh Kanon so chairman, chairman so would not be recommended as 2 posts are already open. This is after 3 years or 3 years. The SLC has come to the decision. Then the petitioner has challenged this before this honorable court, the decision of the SLC, and your lordship was pleased to issue notice. That case, that is your lordship will find.
59.
That is page 59 for instruction. Page 59. So, my lord, instruction was sought for, my lord. In the meantime, my lord, this impugn order has been passed, my lord, during the pendency of the writ petition.
This impugn order is passed by who?
Passed by, my lord, Principal Secretary, my lord, during pendency of the writ petition.
In respect of what?
In respect of the petition, your lordship will find page 56.
On what occasion this order?
That is the thing, my lord. He himself, my lord, whether he was directed to be, my lord, replied about the writ petition, but instead of giving communication to the.
Is it under the direction of the court?
No, my lord, no. His office own.
So,
Yes, my lord. So, my lord, we have challenged. So, the honorable court has given liberty to challenge. Last but page 56. Earlier, it was a vacancy was not there, so he could not be accommodated. Now, here he has come to decision that there's some already considerable period has elapsed since that death. There's page 66, last paragraph. Now, therefore, in the light of aforesaid judicial pronouncement and considering considerable period of time has elapsed since the death of late so and so, further considering the family of the deceased has evidently sustained itself over the prolonged period, it is observed that the essential element of immediately required for considering case of the compulsory ground has been lost. So, my lord, we have challenged. So, this honorable court has.
No, it is pursuant to court's direction.
No, my lord.
What do you mean, no? See, read the paragraph
No.
53, 54.
My lord, that is in cases of, my lord, in cases of, not in the writ petition filed by the petitioner.
May not be. No, it says he filed a writ petition 5125. Where is the order 16525?
That is in connection with a memorandum has been issued. My lord, a memorandum has been issued by the government and all cases cannot be considered.
Where is this order dated 16525?
Yes, my lord. No. How, in my case,
First, tell us what is that court's order 16.
Yes, my lord. That is that, my lord, that memorandum has been issued, my lord, that 15/9/24.
Have you enclosed this order?
No, I have not enclosed.
So, get a copy of that order.
Okay, my lord. I'll
what is this order?
I'll place.
There is a clear narration that
I'll
the
place, my
court
lord.
has, by order dated so and so, directed authorities to obtain up-to-date instructions.
Yes, my lord. Yes, that is what the memorandum has been issued in that case.
So let us.
Okay, my lord. I'll produce.
Mr. P. Sinha, London County. 6 liberty to produce dated 16. 525 passed in WBC 5125 of 5 earlier by. Listed again after 1 week.
Yeah. All right.
Mr. A. Chakraborty for state down. State respondents.
1 point. All right.
1 4. Council. Why do you want to withdraw?
Because they are just after filing the they pass the order. I have to
Submit that the appellate authority in the meantime and rejecting your contention, rejecting the appeal. Therefore, that order is also required to be assayed. Therefore, 6/30 to be file a fresh. Prayer made is not objected to by ESDI. Conditions stand dismissed. With liberty. There's no question. Pending either open. This can hurt you. Some orders were passed.
Yes, sir. Annexes 6 and 7.
6 and 7.
Yes, sir. 7
Page number. 74.
76, 88.
26.
The order. Yes, 88.
'Perceive action. No recovery. If not otherwise recovered. If not otherwise recovered.
In case of two
Better
petitioner
state along with it. So, yes.
two petitioner, it is started.
Huh?
For petitioner number 31 to 37 already started.
Already
Started.
started what?
Recovery started.
Therefore, we are saying no recovery, subject to same not being recovered in the meantime. Non-criminal. These matters are fixed. Third, counsel for parties issue notice. Mr. S.S. Roy and CBC appeals for submitted by Mr. Roy that similar matters are fixed on 26th of March.
One of the cases 555 of 2026.
Where one of the 555 of 2026. Accordingly, let this matter still again 6 along with WBC. 6 to 10.
Pursuant to the order of this honorable court, my lord, a DPC was held in 2024, my lord. At page 111 is the DPC, my lord. That DPC, my lord, 6, my lord, may kindly come to page 114, my lord. So, my lord, this is a promotion to the post of deputy director, my lord. So, in that, my lord, the cadre strength was 6, my lord, vacancy was 6. And Dr. may kindly see, and the down below, my lord, the last paragraph, my lord, DPC has considered only promotion of 5, recommended 5 persons, my lord, 5 number of posts, with giving a prospective effect from 2019, my lord, all benefits. But my case of the petitioner, though it is a zone of consideration, is serial number 6, my lord, he was not considered. And thereafter, he approached this honorable court, my lord, and if notice was issued, my lord, and pendency was not the bar to consider my case. Thereafter, my lord, I have been promoted, my lord. But my promotions order, my lord, at page 146, my lord, where, my lord, I have been promoted with immediate effect, my lord. So I am praying, my lord, in this case, I am praying for the retrospective effect as given to the similar situated person. My lord. I am praying for notice.
Third, it's written. Mr. Radhor, State Council, respondents, of the respondents. In a period of stop. Apply.
Upper case, my lord. Similar case is page 1.
Where is that order?
Page 129.
129.
It's from
129. Third council for party. MSN. For finance. Dispose.
It
Yeah.
also covered case loss in minimum scale of pay.
Minimum scale of pay.
That's we will find page 54. The order passed by your lordship. WBC,
Yes.
Page 50.
After verification. Yes. Third council for party. Disposed. MSN Chaudhary. You're appearing for forest. MS Kulika for forest. MS Kotakul for.
Right. Lordship, it's matter. The petitioner is the wife and deceased employee also. The discrepancy of what it took place, Lordship, the petitioner's first wife died in the year 2005, Lordship.
Let notice go.
Lordship.
Let notice go. Third council for party. Yes, for what? Here's an accepts notice on behalf of. Yes, after the returnable.
Right. Against the transfer order,
Transfer order.
within 6 months, I am new plus of 6 months. Within 6 months, I have been transferred.
Where is the earlier order?
Earlier order is the page 22.
22.
I was there from Lakhimpur to Nagaon, and on 16/8/2025, I have joined in Nagaon. 16/8/2025, I am in Nagaon, and my lord,
Again you are transferred.
I am transferred, my lord.
Why? Mr.
There is no any urgency, my lord. But sir, I have two kids, my lord. I gave birth to 2 kids, my lord. Twin kids, my lord. I have gave birth twin kids, my lord. Only 1 month ago. Why is it disturbed for me, my lord?
You are reminded by the government council to make the submission.
I am written here. I mean, but my lord, this is
Yes, third council for parties. So this dictionary page 28 order. Bill number
my lord, page 29H, my lord.
29H. By so and so order, whereby the petitioner serving as district librarian. District librarian. Wow. District library. District library. It's only Murigaon, nearby. Nagaon, Murigaon.
That is correct, my lord. But I am serving there, my lord. I have 2 kids, newborn, 1 month, my lord. The doctor is there, my lord.
take leave, CCL. You're entitled to CCL leave.
So, the science specialist is they started in Morigaon, Nagaon I am in Settle, It is only for 6 months. At least one year.
That she was earlier transferred by me.
No, I am from Blaga.
Submits that terms of the office before it updated. Nine. Sir is to be transferred without completing 3 years at a particular posting unless where such transfer is required in exigencies of public service, the approval of the chief minister is required. So, counsel for the petitioner submits that the best of her knowledge, best of his knowledge, specific permission has been taken. Submit that transfer order. Ready to be but parents side it's finally take to transfer order. Hearing the respondents. That like to obtain instructions whether the transfer has been carried out by following the formality prescribed. List again on 20. Let it be on 20. Till then,
Monday.
transfer order.
Monday.
Today is Friday.
It's Friday. Saturday and Sunday is closed. Monday.
Get the order. When you show us that it is done, we'll vacate the interview.
Definitely. Monday.
All right, but if you can't get it on Monday, we are making it. We are confirming the.
Yeah, I will. No, at 2 minutes, he can obtain it about 4 minutes.
Third day for interview. Then it's on Monday. Let it be on where? Let it be on 18th.
18 minutes, till then. Then we'll have
18th. It's on 18th. Next week. There should be no transfer order in respect of the reputation. 18th. It's on 18th. Serve extra copy in the during the course of the day. The response. Heavy. But how have you come to know about the writ petition? You must be on caveat. We have not even issued notice. When we may not even keep this petition alive. It is only in the event the petition is alive that the question of imprisonment will come in. Unless you say you are on caveat, then we have to hear you.
Actually, the imprisonment application was filed after my writ petition was registered. So therefore, they have the registration number also. I'm not against it being imprisoned or not. But the issue has been put a quietus by the committee, by this honorable court, under the orders are under suspension. Now we are a totally different thing.
No,
NSC's
what happened exactly?
lordship. There was an allegation of sexual harassment by me on her.
The point in keeping it pending. You know, observe. We may see something on merit, but we can't say that there's nothing on merit and keep the writ petition pending.
Then I can have the inspector.
That to examine it. Granting a stay, but when can you get that information? By Wednesday, Mr. Bonik? Are you willing to?
No, I have to follow whatever follows, but they're getting an instruction, they'll not insist on that.
You are transferred from Sri Bhumi to where?
Golaghat.
Golaghat. Monday.
Monday.
Third, then it comes to
99.
30. 0226. Whereby the petitioner is transferred from the district of Sri Bhumi to Golaghat. You're an EUD assistant, governed by the ministerial service. Inter-district transfers are allowed. That we don't know, but if you're not permitted, you can't do it. An UD assistant. Right. It's transferred to be from Sri Bhumi to Golaghat. Once of the petitioner is that this transfer order purportedly initiated at the instance of a lady. Are you arraying her as a party? Lady who had earlier made allegations, sexual harassment against the petitioner, and the proceedings of which are currently suspended by the court by orders dated 28/11/2025, passed in WPC 6765 of 2025. Internal counsel for the petitioner therefore submits that firing in November 2026, and therefore the end of past year in service. However, appearance of the suspension order by petition 9/16/2025, hereby by order dated 17/12/25, prepared with the suspension order issued. Petitioner grounded case of the since suspension was set aside, even in terms of the judgment of the case of the there would be reinstated, but in a different district. Government has that, therefore, the tribunals of irregular. Mr. Here, that you filed an you filed it. Filed a IA being IA civil number. IA civil filing number 3062 2026, whereby an application for impediment has been filed, seeking impediment in the stage. I'd like to complete the instruction as to the on Monday. Same instructions. Fine.
Right. Deeply open.
Huh? Won't give effect for 2
Wait from
because he'll be required to carry out the order. Once an order is passed, but carry out the order. May proceed against him. May proceed against him, disobeying the order on a later stage. What difference does it make on Monday? Yeah, say we may not. We are not inclined to continue this petition. I am sure the counsel for the petition has understood.
Correct.
Because he is keeping the proceeding suspended by way of an injury.
Correct.
And we should get this matter listed also.
Oh, I checked up. What happened is that 28
Either Monday or Wednesday.
I checked that 28/11, one was reserved for judgment, and other case interim order was passed, both listed on 2 different courts same day. And judgment was pronounced on 17th of December. Therefore, this order was not effective. Could be that. I checked the minutes.
On Monday, you make a mention if you require, we can list both the matters together. If
Not
subject to this matter, like
wait for
it's the stage of the proceedings, criminal proceeding. Yes, Mr. Gouai. Get instructions heard. Counsel for party. Issue notice or you'll get instruction. Better to issue notice. It's returnable 2 weeks. Mr. B. Gouai, learned state counsel, represents the respondents 1 and 2, and so Mr. Gouai. What is the stage of the proceeding, departmental proceeding?
Inquiry officer has been appointed, my lord, recently, my lord.
Stay immediately after 2 weeks. Thirty days for interim would be considered on the next day for listing 30. It's not issued the notice. Have you issued notice? Initiate the inquiry. Presenting officer appointed or not?
Appointed. By the same order,
By the same order. So he has to initiate the inquiry. Don't it has issued any notice to you? You're fixing it on 30 immediately after 2 weeks. If there is any notice, you approach the court. They can mention. No notice has been issued for you to appear. What interim orders you want? They not even proceed. They've appointed the inquiry officer. Inquiry officer has issued notice to proceed. So you have to be called upon.
I could not find a reply to the so-called notice properly, Madam, because of the tendency of the reply. I have stated that, Madam, I could not, why I could not find the reply.
Examine that. On 30. Yes.
But it's a case of a frequent transfer. If you Rachit to kindly come to the list of dates. And list similar 29-21 petitioner was transferred to Gauhati. Then my lord, after 4 months or 5 months, I was transferred to Gauhati. Then after 8 months, I was transferred to Gauhati. Then my lord, after about 14 or odd months, I was transferred to Dibrugarh. Now again, I have been transferred to Kingston. Now, my lord, whatever had happened earlier is okay, my lord. Now, on the eve of the election, a general excess of power has been exercised. Don't you know in the two situations, normally an election of one who has completed 3 years, and other one who has not the home district. My lord, the petitioner's home district is not Tinsukia. His home district is not Tinsukia, therefore there was no occasion to transfer me out. It's an absolute without jurisdiction. Well, to assume jurisdiction, you must have the power to undertake the exercise.
You are now you are challenging
Now,
the
what
order
has
of
happened?
transfer from
Initially
out
when
of Tinsukia.
no, initially when transfer order was passed on my lord 6/3/26, I was not given any posting. In my place, respondent number 4 was brought in from Lakhipur. Now, my lord, after filing of the writ petition on 9/3, I have given a posting in Gusaigam, that is 750 kilometers away. Well, how can this be done, my lord? The exercise of the power must be traceable to some legitimate source. Legitimate source is the transfer policy, and second, my lord, I do not belong to Tinsukia, doesn't belong, is not my home district. So therefore, it's an arbitrary exercise of power. My lord.
Yes. Right. Are you on leave?
Yes, my lord. I'm on leave. Actually, my lord, while going back from Gauhati, my lord, he fell in Jorhat, and he was in Jorhat for treatment. Now, kindly see from 21 to 24, 6 transfers. And my lord, as I have already submitted, my lord, Tinsukia is not my home district. Therefore, I cannot be shunted out. Transfer policy is 3 years. I have only completed 14 months. There cannot be any administrative exigency like this. Transfer order, my name is not there because I was not given any posting, my lord. In transfer order, dated 6/3/26, if your lordship should kindly come to page 39, my lord.
39.
Yes.
Yes.
My name does not figure. At page number 39 on top, Jonathan Goswami, who is an inspector of excise in Lakhimpur, he sought to be brought in my place. I was not given any posting. On
Why?
that, no, not given, my lord. This shows their arbitrariness.
How is it transferred out?
On 9 they have given. After filing of the writ petition, my lord. When we have taken one of the ground taken in the writ petition is that I am without posting, then they issue a posting order in Gusaigaon.
So that is all right, but you are transferring somebody in his place.
Uh,
What will happen to the person there?
at Gusaigaon. Three other persons. My humble submission is very simple. I have not completed my tenure. Insutia is not my home district. On the eve of election, how do you transfer? That's the issue. Let us not concede an arbitrary power at the hands of
No,
the
but
executive.
are these orders issued on the ground of
Yes,
election
yes,
being there?
yes.
From where do you say?
No, they themselves say.
Where?
My learned friend also made their submission. No, these are the exercises undertaken on the eve of election. Because when a day or two will not the model code of conduct will be enforced, then they cannot transfer. And para 5, we have made a statement, Miller. I know, I'm not disputing.
Where is your additional affidavit?
Yes,
I see.
yes.
Not, but is it filed?
Yes. Yesterday.
You
We
had
just
given
filed on 9.
permission for
Yes. Page 46, Miller. Page 46, Annexure 9. The second one, in the interest of public service, Niranjan Das, Inspector of Excise Tinsukia, is hereby transferred and posted as Inspector of Excise Gusaigaon with immediate effect. It was on 9th. In a more or less in a similar situation, Miller. Yes.
What is the ground on which the other persons are transferred?
No, they all on the eve of election, Miller. There is a similar order. Lordship will kindly come to para 9, Miller. Same excise department. Transfer is an exigency of service, and normally this code will be loath to interfere with such exercise of power which are exclusively within the domain of the employer. At the same time, the aspect involved in this case is frequent transfer, which has to be examined in the context of the reason projected to defend such an order. Earlier transfer of the incumbent involved in the litigation were 12/2/24, and within a period of less than 4 months, the instant transfer order has been issued. Though it is the contention of the department that earlier transfer order dated 12/2/24 had to be issued on the instruction of ECI, which were on account of general election, it is a matter of fact that incumbent had to move from one location to other. This court also looked into the reason cited in the note sheet. As would be revealed from annexure, it has been stated that due to certain change of the rates of ad valorem levy, transfer had to be effected to put right officials at the right place to stop inflow of liquor from the neighboring state. The reason cited cannot be held to be justified at all, as governments are in a particular cattle have to be treated at par. Data for transfer which are involved in the present 3 cases are not from locations which are in neighboring area of the state of Assam, as noted above. Frequent transfer. It was also a case of frequent transfer. This honorable court, after realizing that normally lordships will not interfere, but in an appropriate case, there is a scope to interfere.
We have to call for the records. You show us the records.
Yes.
No appeal against this.
Anyway, Lordship,
No appeal against this order. No appeal.
no appeal.
Only asking you whether any appeal is in file.
Issue is frequent.
Then it's not a judgment to say that for all
In every
cases
case.
it will be applicable. Here is the case where the person was on leave. Here is the case where he was on leave. Produce the records,
Yes.
file noting or whatever is there. Let us see.
Yes.
Mr. Govind, produce it to justify that these are administrative exigencies. Or we give a stay, give us an option.
Till then, because they've already issued.
Your private respondent and all that.
No, Milord. That may be, Milord. Only thing is, Milord, so far a communication has been issued to me. Why I have not joined, why explanation has been called for. In that view of the matter. The status quo as on
We'll
today
say
remains.
that in view of the pendency of the petition, coercive action against
Yes,
the
yes,
litigant.
yes. No courtship, yes.
No coercive.
Yes, yes.
Third, petitioner before the court is challenge. You're challenging both the orders.
Yes.
6th and 9th. 6th March.
6th and 9th.
2026. Thereby. Petitioner. 3/2026. Subsequently, by the
In a span of 5 years, he has been transferred 6 times.
spent 5 years, 6 times in the state. Many purported to have been done. Election Commission of India guidelines of litigation. Then also therefore getting back to the petition. Private respondent and time. Saxena. Saxena reported. This again on 17.
Till then, Milord, no courtship.
17, 18. 18. Action. March.
And 9 March.
March. 20.
Evening. Yet, my lord, sir, I have to. I need some time. Lord, you can take it after some time because I was on the respondent side. Now I've changed this side. I need some.
58 is what?
I'm selling a transfer here, man. So I need some time to shift. My lord. Some time. After some time. All
After
right.
some time or someday?
No, so after some. After some. All right.
Yes. Transfer.
No, order of transfer, my lord. The order finds at page 19. The common order. Sorry. The appears at page 20. First order. As the public service, the Hemanta Kumar Kodikahi is the petitioner. Assistant Executive Engineer C. Workhead 3 Territorial Road Subdivision is hereby transferred and posted in the same capital registered in engineer Panai Road Division, that is in Karbi Angalam, against the existing vacant post with immediate effect. Now to further order. The Hemanta Kumar Kodika shall hand over current charge of GE Workhead 3 as the Malakar, who has been promoted and posted in my place. Now, this order I am challenging only one ground. It was transferred to this place, my lord, in 2024, 10th of September 2024, that your lordship will get. The public service, Hemanta Kolika, expenditure, assistant engineer is transferred. This is an order dated my lord 10/9/2024.
Just a minute. Yes.
And there is an OM, my lord, your lordship is aware. It says that, my lord, if a person is being transferred.
Again, we'll have to. You have to tell us the reasons why you're transferring people contrary to the OM. How much time do you want?
That time, my lord,
Same order. Right. Council for part. Dispose it off within weeks. Dispose it off. Interim order. Receive action against the petitioner till 31st. Coercive action against the petitioner. That's all. We are not staying the transfer order. We are saying no coercive action. disposed.
One of them, my lord.
Why consider? Then you'll say consider this judgment, that judgment, and so many other judgments.
Because of that OM only I am.
We are mentioning that in the order itself, that in terms of the OM.
Therefore, that is 45.
45. But why the provisions of the appellate authorities are not being followed? There is a provision for appeal.
This could happen, my lord, challenging the earlier order of transfer.
Yes.
And your lordship has set aside the order of transfer on the ground of private response. And my lord, your lordship directed that your order your lordship will find, my lord, at page 24, 11, page 36. The judgment starts at, my lord, page 24. Payment part is at 36. Comes in the paragraph 21. While this court does not dispute with the proposition that the transfer is an incident of service and ordinarily interference with transfer order ought not to be encouraged in judicial review, the peculiar facts which have been placed before the court reveal that the interim transfer order dated 26/2025 is not a transfer order issued in public interest. Such interpretation cannot be given to a transfer order which was issued or initiated on the basis of a request made by the individual officer. Ordinarily, when a transfer order is made on request, the seniority of the person concerned at the place of posting, where the choices indicated, if such a seniority list is maintained, is normally at the bottom of such seniority list, although such is not the case. The fact remains that the reasons placed to the court by the department do not inspire a conference to return a finding that the interim transfer order was issued in public interest. Accordingly, the repetition stands allowed. Interim transfer order dated 26/2025 stands interfered with and set aside. Concerned department shall pass consequential order forthwith. Against this order, my lord, the private respondent approves the, my lord, division bench. And if your lordship sees the order in the division bench, is it starts, my lord, page 39, is 11. Did not interfere with the, my lord, order of your lordship. Transfer one paragraph. By the interim judgment, a fresh order of transfer is now required to be passed, accommodating both the appellants and the respondent number 1. Let such order be passed, notwithstanding the pendency of the rejected. By accommodating, my lord, both the petitioner and the private respondent. Point of that, my lord, the passed, my lord, petition and the same.
And subsequently, what happened? Fresh order was passed.
Fresh order was passed. That is under challenge in this. 45.
Happened to the writ appeal.
Writ appeal is pending, my lord, because on what happened on the last day.
You have to point out to the court that this order is passed in terms of the liberty granted.
On, my lord, 11/3/2026, my lord, this 44 your lordship will find. This 44. On behalf of the government, my lord, the time was taken for passing an order.
No.
But on the same day itself, my lord, this
now you see, effectively the writ appeal has become infructuous now.
Yes.
That too on a liberty granted by the court. Court said that notwithstanding the matter, fresh order is to be passed. Now it has to be pointed out that fresh order is passed.
My lord, in fact, the Indian bench has passed the order, my lord, without staying your lordship's order that Passes this order according to order.
That earlier judgment is also now a fresh order has been passed. So the earlier judgment will have no effect on this fresh order. It's passed pursuant to liberty granted by the but to decide on this, the appeal is still pending.
What happened on the 11th, my lord?
Why that in terms of the liberty granted, this order is passed, which we are challenging it. Now, perhaps the appeal reversing the earlier deciding the same, parties are the same.
What is the same, my lord? The grounds that were argued.
Grounds which were urged earlier, you are re-urging it now. Grounds which are urged by the government then are re-urged now. So it is good. Then what are they have to be looking for the finding that not that it was in public. Then what happened?
And then we have another order before.
Carry it out, but what can be done now? Yep. By the earlier order, what had happened? You were transferred from Gauhati to Dibrugarh. That was set aside.
Proceed.
Then the matter went to appeal. So you remained in Gauhati. Matter went to appeal. Now the appellate authority, the in terms of the liberty, they have reconfirmed the same order.
Same order, my lord, and now it is again same, my lord, public. And that was the.
No, you are again transferred to Dibrugarh, and the gentleman is being transferred to Gauhati. Same issue is pending before the appellate court. Say it did not interfere. It says you are at liberty. You will hear the appeal on merits. There were two ways to do it. That the issue which I am required to call upon is still alive before the principle. Still alive.
By giving liberty to the authority to pass an order as was directed by your lordship, my lord, that means, my lord, there was no interference of the
But entirely by the orders passed by the court. Liberty is granted, we have seen it. They have passed an order. But the appeal is pending. And the last order says released on so and so, we want to hear it on merit. Consider rising the that or this order itself may be considered since similar order has been similar issue has been considered. I think we consider that since the correctness of the judgment is why not consider the correctness of this order? Same thing.
And two things, my lord.
Say that is there are two different orders. bench will continue on its own, then its order. Eleven. 11.
31 thing.
31. Can I have it on first? What's an order to be? Mr. N.K. Chaudhary, singing insisted by Mr. M. Chandra, submits that the by filed by the petitioner being WC 35855 by order dated 2/12/2025, petition was allowed transfer of the same before the appellate court by the respondent being writ appeal 9 of 5, where by order dated 18/12/2025 while considering the writ appeal permitted the fresh order of transfer passed accommodating both appellant and the respondent number 1. Such order was directed to be passed notwithstanding the pendency of the writ. The matter was thereafter posted to be heard on merits. Directed to be listed on 31/3/2026. Then a person granted by the report 6 will be passed by the said order. The petitioner was again transferred from Gauhati from our post as from our posting as Registrar Labour Code Gauhati. Is transferred and posted as Registrar Industrial Tribunal Dibrugarh, and the private respondent was transferred from the Industrial Tribunal Dibrugarh and posted as Registrar Labour Code Gauhati. This order is under challenge. The ground that where the bench has already concluded that this order passed. Request cannot be termed to be an order passed on public interest. The department has proceeded to pass a similar order, ignoring the judgment of passed. Mr. J.K. Muswami submits would like to complete the instruction. Considering the issues involved, at some length, Mr. M. Chaudhary, Senior Counsel, again after 1st of April. Or we defer it by 1 week. So that it then submits that the matter be deferred 1 week, and we may be permitted to instruction required to be taken in the matter. This matter after 1 week. Yes, which date? After 1 week will be 23rd or 25th, 27th, whatever date. 25th of March. Okay.
The petitioner, Mr. Lordship, was a CRPF SI, currently posted in Ameriguk. He's been transferred out to Jharkhand, Dantewada. His petition assails this in two grounds. He's a caregiver of his wife, and they had two daughters. One daughter passed away in the month of January last year till after that she is suffering from mental issues, madam. She is undergoing treatment. Second, madam, the second daughter is preparing for NEET, which is be held in few months, madam. And thereafter, madam, transfer order also will find at page 20, page 17.
You are claiming the exemption of transfer
Exemption, ma'am.
on medical grounds.
Yes, ma'am.
But medical grounds are specified here. It is only in these grounds that you are entitled.
Madam.
Under what category?
Then another issue is there, madam. I'll point out. Lordship will kindly come to page 19.
19.
19. They've rejected, madam. But madam, rejection, since it is an administrative order.
Rejection of what?
I had madam represented, madam, at page 18, madam. That either you retain me in somewhere near Gauhati or somewhere in Assam, or for just give me an extension for 1 year. They have rejected. I represented it. So my rejection, my lord, you will find at page 19. Just a remark is the rejected. But administrative reasons has to, they have to, these decisions has to contain reasons, my lord.
Reasons are there in records.
And thereafter, my lord, its certificates annexed at page 21. It goes on to, my lords, page 28, certificates, my lord. The wife, my lord, of the petitioner.
Why was it rejected?
That I understand, but that I'm not pressing too much.
On what is the basis you are challenging? This
Well,
exemption, you have to show that you fall under any of the category.
That apart also, my lordship has to be read down, because there might be some other issues also which might not be covered by this. Because admittedly, wife is undergoing treatment at GMCH, certified by a psychiatrist also.
But that facility would be available wherever you are posted.
No, my lord. Issue is not the only treatment. Issue is the aftercare, my lord. I'm not denying that facility is not there. After a person goes to the hospital, there are some after coming from hospital.
So all these things will have to be on the basis of medical advice. Where is that medical advice?
My lord,
you say that she requires constant aftercare.
I'm annexed, my lord.
Where is it? Or it is the case.
Kindly see page 27, issued by GMCH. Though it doesn't spell out, but there is
no medical advice that she needs to be under constant monitoring or medical advice or anything.
She is advised to continue treatment. She is the only caregiver.
So, but you said you are the caregiver.
She is the only petitioner is the only caregiver. There is nobody else.
Petition says you are the caregiver.
Yes, I am the caregiver. Apart from that,
you are the caregiver of the only caregiver.
One passed away, one preparing for need, and this wife is there. And petitioner also had a mother who passed away in the month of.
Difficulties are there. Like the environment.
I understand, my lord. I just retention for 1 month, my lord. And in fact, my lord, unfortunately, the mother of the petitioner also passed away on 25 to 26.
Show us why. Can you show us why the documentation is taken? Next Friday.
Next Friday.
In any case, your marching orders will be on first.
Right.
List this matter again 20 March. Let's see this. against the transfer order issue. Then that is white couple. Even in white. Well, hold it. I read our bill is scale minus. Come to the last order minus 2 to 2. Matter would not be taken up. 26. Bring instruction from the office. What is 1911? 19. 1911-25. But my lord, I have the instruction from the liquidator not to proceed with it. Huh? I have the instruction from the liquidator, my lord, not to proceed with it. Not to proceed with? With that case. He doesn't want to complete it. Does not want to proceed. Huh? Whatever will be there, he doesn't want to proceed. No observation is called. Heard, Mr. And Mr. Dimalagar. File challenging passed by the award dated 31/7/2015 passed by the CGIT Company Court in reference case number 405 respondent number 3 right, stated without any backdating. Without backdating. So during the pendency of the writ petition. So later thereafter proceeded with the petition with the writ petition pending. So Mr. Chaudhary represents the liquidator. Submitted today written instructions that the liquidator does not wish to proceed with the liquidation any further. Stand dismissed. Pressed. Any interim orders. Past cell stand vacated. Pending IAs are also dismissed.
Deep.
Where is the direction of the court? 29. Dated 31/7. Where is that show cause notice?
I have blended continuous petition. Page 34. They have issued so called notice. We have submitted our reply notice. Since removal orders has been set aside, Lordship. So, but they have not allowed us to. They have not allowed us to join in.
There is no direction for reinstatement.
But removal orders has been set aside,
But
Lordship.
there is no direction to reinstate you.
Setting aside of removal orders amounts to allowing of.
That interpretation you have to seek separately. This order
Lordship.
at page 29 is very clear, setting aside of the show cause notice.
Lordship.
What consequential orders are to be passed has not been elaborated by the court. If it is your case that no, you have to be reinstated pursuant to this, so there is then further consequential orders you'll have to pray for, or clarificatory orders you'll have to pray for. But if you are filing a contempt, contempt would be in respect of the directions directed to be carried out. This is the contempt.
Lordship.
Contempt is an
But the matter is pending with them. Similarly situated persons were terminated, Lordship. They have approached the
If you don't want to understand, we pass orders and proceed. We are trying to tell you that page number 29 is an order where reinstate or freeze your salaries or anything. On the clarification in that order, you have to file an application seeking clarification. That has not been done. Now, in terms of this order, they have withdrawn the earlier order and issued a fresh so forth. So, where is the contempt?
the matter is after one.
What we
That's one request.
what judgments to what effect?
Because removal orders have been set aside. So the petitioners
One opportunity, all right, to show what? That the order has not been complied with. There is no specification in the order.
I want to place some Supreme Court judgment.
Place it at 2 p.m.
Next week.
No.
Monday.
How do you say that there is a Supreme Court judgment? Do you have it? Do you have the Supreme Court judgment?
1 week time.
Do you have the Supreme Court judgment?
I have one.
You show it to us. Let us see the Supreme Court judgment.
Para 21. Para 21. That is clear.
Proceeding in contempt.
But here it is clearly specified that once the termination
So
order
that is a clarification you are inviting from the court in a contempt proceeding. That is what we are trying to tell you. This clarification, assuming this is correct, you have to get it from the writ court, for which either you file a review application or an IA, whatever you want. But the contempt is for willful disobedience of the order. The order is very clear. Not proper for a contempt court to interpret an order in a manner when it is not clear from the order what was the specific direction sought to be interpreted. Order is clear.
order is clear.
That
The
you are
recovery order-
permitted to withdraw and issue afresh. What will happen to your status in the meantime? What could have been clarified, but it was not done. Now, how can in the contempt proceeding we say that it is contempt? First, you want a clarification. First, in the order, there is no specification that nothing is to say one thing, termination order. Filing contempt saying that this is violation. Why? Because will withdrawal of the termination orders imply automatic reinstatement. That interpretation you are seeking from contempt. Also saying that this is a violation of the direction. We interpret it. Even then the contempt case has to be closed because the interpretation has come now. Then they will have to be given an opportunity to comply with it. Not judgment, not authority. Contempt proceedings, such an interpretation is granted and proceedings be initiated for violation.
that I want from that.
No time, no time.
At 2 p.m. Lord. At 2 p.m. Short. Apply.
Direction here,
Done.
27. Does not imply grant of compliance of the order. Instructions and appraise the court.
Last occasion also.
The direction was to give them the benefit of vendors. Now you are in the process, your names are included. Does it mean we record your statement?
Last occasion also, my lord.
How much time can you require? Question is, why has the order not been complied? You have been given some time.
Yes, sir.
You know this time is not sufficient for you. You are within your rights to pray for extension of time. No such step was taken. You are in contempt every day. Whoever has contributed towards the delay, will contempt whether or not that person is the party respondent or not. They are on the verge of complying.
My lord, kindly see page 29, my lord. Already director has allowed me to, my lord, to draw down, my lord. From 9/4/2025, my lord. Now they are
By who? Guidance. As on date from your submission, we understand it is not. One time till first of it. We'll give you, provided you give us an undertaking that the order will be complied on the next day. There must be an explanation why it has not been done. If you have an explanation that yes, because of this problem, that problem, these things are not done, but it can't be a vague description that it is waiting, approval, whose approval? The approval is waiting. What higher authority? Which is that higher authority? And why the higher authority does not have time to give the approval? Yes, madam. We'll give you time till first. We want clear instructions as to what has happened, before whom it is pending. And if we find that it is not being done, we are proceeding with court. Counsel for the which department? Respondent 5. Study. The petitioner has been included. List of eligible candidates for grant of benefit. Vendors. Terms of the directions contained in vendors quoted in so and so. Submits only the approval indicated. It's time to complete the instructions list on 1st of April. NSNS Takuya based on petition. Contempt petition. 1st of April.
first of April. Obliged.
IFO?
One of the pair is with regard to my promotion. I was in the zone of consideration, but
What is your writ petition for?
That's the departmental.
Writ petition.
Now, since at that point of time when the IA was filed, I was in the zone of consideration, but not promoted. At that point of time, all my batchmates were promoted. The other lawsuit will find
What is the prayer in the IA?
lawsuit. I need to be promoted.
Can't be promoted.
But if I am
How can you be promoted? On the same level.
the meantime, my juniors have been promoted, and I am
Once
required to serve under them. There is serious advantage. I find on my part.
Was that in spite of departmental promotion, the department proceeding?
And relying upon it.
What did the rule say?
After the rules, it has to be under seal cover lawsuit, but since there is no delay, and there
Then
is a
you know that
requirement
delay you pursue your departmental proceeding.
lawsuit, that's what I am trying to do. Lawsuit, what has happened, there is a direction of this court to provide me all the documents which I paid for in the letter lawsuit. There is a same order which lawsuit is filed at page 17. But lordship, they themselves admit that they have not been able to provide that one. And that is causing the delay. Still, lordship will kindly turn to paragraph 12 once. Lordship, paragraph 13. Trying the balancing process, we are of the opinion that quashing of the charges and of the order appointing inquiry officer was not warranted in the facts and circumstances. More appropriate that in the interest of justice as well as in the interest of administration, that the inquiry which had proceeded to a large extent be allowed to be completed. At the same time, this is important, directed that the respondent should be considered fit for promotion without reference to and without taking into consideration the charges or the pendency of the said inquiry. And if he is found fit for promotion, he should be promoted. Direction is made in the particular facts and circumstances. Though we are aware that the rules and practice normally followed in such cases may be different, the promotion so made if the inquiry shall, however, be subject to review after the conclusion of the inquiry and in the light of the findings in the inquiry. It is also directed that the inquiry against the respondents
The facts and circumstances of the case. That is mentioned in the judgment itself.
But then maybe also the department does not have the documents now.
It does not have, you pursue the departmental proceeding. You have,
But
you have filed the writ petition.
yes, sir.
What is the writ petition challenging what?
Challenging the query proceeding.
Then?
Departmental proceeding as well.
Then?
What would happen? The whole proceeding was based upon the citing by the NCB.
Now, who saw the respondent? You are not there. This is the stage of the inquiry. Witnesses examined.
Yes. Half of
Examined.
them have been examined without giving me those documents. Yeah, but this court and this court directed them.
Have been supplied.
No.
You get the instruction why the documents are not furnished. Page number, paragraph. Try move. Die.
So reply against that.
Time.
Nine, 10, 2020. Therein against that point number one, I don't have any objection. Regard to that letter, which they have given, they have provided. Regard to that copy of charge sheet, complaint and CW serial number 24. Part of it has been provided. Part has not. Regard to point number three, handling and report by an SIT. The criminal based logic. And basing upon this logic, this handling the investigation was to be done. That is fighting for me to prove my innocence. But that has not been provided either. The next page, some part in the right hand side, I had written in logic.
What are the charges against you?
Fine.
Yes.
Fine, Lordship. Charges is at page 47, article 1. What had happened is that,
You were posted at NCB at that time.
yes, Lord. Lordship. One, Anup Kumar Gupta was leading the team and I was opening him, Lordship. And at that point of time, Lordship, some negligence in the investigation alleged, Lordship. And Arshid, Lordship, they have said that I was leading the team and all the charges are based upon that fact only. Now, fact that Anup Kumar Gupta was leading the team and I was only officer under him.
What we are trying to understand is when the proceedings are made, there is an inquiry officer, there is a presenting officer.
Yes, Lord.
Now the presenting officer is to present the case of the petitioner. In view of these charges, you have filed your WS written statement. Now, once you have filed your written statement, what further documents you want?
Lordship, that handing and taking of a document.
Why have you filed your written statement without that?
Lordship, I sought for documents, Lordship, and
You may have sought for, but you have filed it. Did you approach this court saying that these documents are vital and without it you can't complete your written statement?
Lordship, I sought for those, but they didn't do it. That written statement was just to my right to.
That you can't keep on.
No, because
It appears that at your instance the proceedings are not completed. On one hand, you come before the court saying the proceedings have to be completed.
one document, and in fact, on the last occasion, the reply they have written to the NCB, Lordship. They got to provide.
Whatever may be, but the documents have filed your written statements, the proceedings are now underway, inquiry officer is there, presenting officer is there. At this stage, you are still foraging for documents. That to be for the NCB movement.
But now, Lordship, there is an interim order in my favor, and they have not put it to challenge. Until and unless that is
What is that
overturned,
interim order?
Lordship, kindly very that it's at page 17 of the IA, Lordship.
Interim order dated?
Order dated 27/6/2024. Page 17.
No, they have, according to them, they have provided, according to you, they have said that these documents are with NCB. But there, you're required to go to NCB and collect these documents.
Lordship, I went there. But
You went there, according to you, the NCB is not given you the document. Who is to verify that these documents are not in the custody of?
Very well, Lordship. The departmental authorities do not have the documents. How can they the departmental?
No, not there. Question is, you are asking for certain documents. Whether these documents are relevant for the proceedings or not, according to the department, it may not be relevant.
I explain why it is necessary, Lordship. Because with the charge,
You may have explained.
yes,
Have you arrayed the NCB people as party respondents? No.
No, Lordship. Because
Then because you're, according to the documents are not being handed over by NCB. Yes or no?
their position, Lordship, not mine, Lordship.
No, you have
sought for those documents.
you have filed a representation saying that these documents, such and such documents are not there, some pages are missing. As per your representation.
Lordship will see the manner they provided the documents.
We are
sought
not
for
here to
specific
look
documents.
It is your representation to say that the documents are not complete. Documents that you are seeking from NCB are not complete. If that be so, then you are at liberty to seek a direction against them, see, provided they again narrate in the party.
I can make them a party, but lordship,
We are not advising you. As so far as the department are concerned, they have all the papers to proceed. It is raising the objection that the relevant documents are not been. Therefore, I am prejudiced. Therefore, don't proceed. And therefore, the court has ordered, all right, provide all documents.
lordship, there is a representation, and basing upon that representation only is doing what I can do.
That representation, pursuant to that, they allowed you, they given you certain documents. According to you, these documents are not known. From the reply which is available on record, yes, the party is. There is no direction to NCB. It is not the case of the respondent that without these documents, the proceedings cannot be completed. And your defense that you won this document. Right, how to get this document. And on top of that, you are now coming with an IA to say that because of the pendency, long pendency, your promotion should be given. When you are a beneficiary of an interim order at your instance,
Lordship, I am, lordship,
you are dismissing your IA.
lordship will kindly allow me some time.
You are dismissing your IA.
Lordship, there is another prayer, lordship. I got to the SIT.
All right, the request upon submitting at some length, the counsel to the petitioner submits that the matter be listed up at the third day, and it's in the response. Judgment is not in, termination order is not interfered with, but we give liberty to prefer an appeal if preferred within 30 days from the date of receipt of an petition disposed of term. You're satisfied? Heard. Counsel for the parties. The petition is fine, seeking a direction. Disobedient. Directions contained in the third, dated 9/1/23,
23 lordship.
passed in WPC number
9/4 of 2020.
9/4 of. So I will say order. Direction. Submits that specific direction. Right. So we'll set aside. Remove the law. Submission that when the order is set aside, it required to be reinstated in service. Mr. Chalial, respondent, Mr. that direction by the court is removing the petition, but there is no consequential direction of reinstatement of the petition. So, rather, they've also been passed, and reply has been filed, and the matter is pending disposal. Some circumstances, violation of the directions contained in the past. By the petitioners challenging the respective prior to the that episode of removal of petitioner and arisen and the direction of the state. Statement in service. However, such finding is required to be handled by a competent board. So, to reach the content, right? Such conclusions are seen. So, application is time seeking clarification or further direction to statement service. circumstances.
Finally, so delay, there is a delay part will come.
Liberty for what?
Finally, that's
For the event. See. By any such clarification. Same is the same option is available. Now there we give history by filing the application or refresh petition as may be advised.
right.
Then 9/2/2026, while considering the this is directed direction equals to direction. Five years more. Five. 1 to 5. For extra steps from 6 to 246. Again, by speed. 1 weeks. You're taking steps by speed moves. Take steps by speed. You have to await the return of service. And make it returnable by
For protection. I listen to you.
stage of the proceeding now.
Proceeding there, last, it was said, it took time. So, coming 18. Let them take time, we not giving them, you're not trying to protect me.
Third, Mr. Esco. LIC. And some instructions are awaited, like for animation. Proceedings are stopped. Under which rules?
For rule,
Environmental proceedings are stopped. Because the submission of the council. Recovery can be made.
no proceeding can be initiated. Yes,
OPA is for recovery.
sorry, it would not is recovery.
Ah.
That proviso your lordship will find.
The recovery would be, we have it. The recovery is to be made following a procedure under Rule 48.
No, my lord, rule 48 says can recover, provided the proceeding must be drawn up either
That's-
during service
That's
or
what we're saying. You are challenging the
No.
challenging the recovery sought to be made under 48.
no, my lord, your lordship has to. I must be found guilty in the offense. That's the difficulty. 45 rule, I have your lordship has got it.
45.
45.
Yeah.
The general condition, even to competently consider that petitioner is primarily guilty and misconduct, he shall, before passing an order, follow the procedure. This is the procedure. And your lordship will find 48.1 loss caused to the 48.1 second paragraph, loss or the loss caused to the corporation if any departmental petitioner is found guilty for misconduct. 48.1
No, you are challenging the proceeding.
proceeding. So proceeding is beyond the time.
I am trying to understand.
Ah.
You are challenging the proceedings
Proceeding
initiated by issuance of charge sheet
starts.
on the ground that under Rule 48, these proceedings cannot be initiated in course of action of the but this is the proviso with regard to rule for recovery of pecuniary loss.
No, recovery because retirement after retirement without no dismissal, nothing.
Recovery will follow a disciplinary proceeding. There cannot be recovery without any proceeding.
Without any proceeding.
There
And
has to be a finding that yes, you have caused loss and we are now required to recover this amount.
I must found guilty of misconduct.
Whatever.
Ah.
But assuming you are found guilty of misconduct, whatever other punishments may be resorted, but no recovery under 48.
No, my lord. Yes, why so is specifically said that no proceeding can be language. Language is your lordship did it.
This proviso you have to read it being true. Recovery presupposes that there has to be departmental proceeding. But
Yes.
if you're loading a departmental proceeding, then you must take care of this proviso that it is more than 4 years of that event, then no departmental proceeding.
Exactly. Here in my case, same thing, you know. Here I am a retired person. They initiated proceeding because of loss and misconduct. They have to prove it my misconduct part.
Yes, Mr. Doctor. Proceeding is on. Subject to correction, Mr. Kutopki. 48 is in respect of recovery or withholding or withdrawing of a pension or a part due. That is the power of the authority. This they can do, which perhaps presupposes that will be a sequel to a conclusion arrived at in any departmental or judicial proceeding, where you are found to be guilty of grave misconduct.
Exactly.
Right? Now, however, no departmental or judicial proceeding is not initiated shall be instituted in respect of a cause of action which arose or in respect of an event which took place before it. Now, this has to be understood only in respect of recovery of towards your pension.
One.
Uh,
The competent authority may withhold or withdraw pension or part thereof, where a permanently or specified period or other order recovery from pension of the whole or part of any pecuniary loss caused to the corporation if in any departmental or judicial proceeding the petitioner is found guilty and grave misconduct, and that departmental proceeding cannot be initiated by providing. They
where is your charge sheet there?
have paid your lordship will find it.
81.
Yeah. Consider page 21. Was issued under
Yes, so,
48(1).
yes, Mr. Doctor, I think the charge sheet is very clear that they are proceeding to invoke powers under 48(1). So if it is 48(1), then you will have to satisfy the provision. Prima facie, according to him, these episodes which are reflected here are in 2015. And you are initiating this on which date?
On success was issued on 1/12/25. The another law, date of issue is the date of issue.
Where is the charge sheet? Where is the date?
Date success without last 23. First day of
First day of December.
25.
Appears to be prima facie barred by the rule 48. Well beyond that period prescribed. No, because the charge sheet is only towards penalties under 48, not any other penalty.
Right.
Correct. But unless you say that subsequent charge sheets were issued, but for the time being, this is the charge sheet and the proceedings are sought to be initiated under Rule 48(1). Strenuously submits that terms of submits that the charge sheet was issued on December 25. Allegations that the petitioner had checks against the premiums and loan repayments and the policy contrary to the prescribed rules. And some of the checks were also utilized for procuring new policies, which constitute serious lapse, etc. Mr. Kotoki brought attention charge sheet to show that checks are dated. Checks dated are from the year 2015, 20. Submits that in terms of 48.1 proviso, third proviso to rule 48.1. The LICA, what rules? Service rules.
Life Insurance Corporation Employees Pension Rule,
Employees Pension
1995.
1995. It is seen that no recovery under Section 48 is contemplated by way of any departmental judicial proceeding if the same are not initiated while the employee is in service, and respect of a cause of action which took place, which third proviso, no departmental judicial proceeding can be initiated against the employee in respect of any event which took place more than 4 years for such an institution. Since it pertains from the year 2015, are all beyond the period of if the date of issuing the show cause, which is 1st of December 2025, is taken into consideration. So it is the submission of the council to the commission that issuance of the show cause is the initiation of the proceedings. Itself ought not to be permitted to proceed against the petition. Mr. Dr. Side submits that without instructions he is unable to submit anything. Such circumstances, there are such circumstances. Stayed again after 3 weeks. Meanwhile, the next returnable date, the proceedings initiated by charge sheet issued on the petitioner on 1st of December 2025. Is there any number?
No.
AP number or anything?
No.
Shall remain stable. Second of April or any date earlier? Second. That's right. So we like to, there was a direction earlier to list it on, I think, 3 months back, but somehow it did not get listed. pass the order. No, pass orders on 20 March. Based on 20 March. We know this. Respondents.
This is an IA for correction of a typographical error. It's stated in paragraph 3. That come up 27th. Suppose these three issues. Yes.
The IA.
What's it in the writ?
Where is the correction?
What's it? Paragraph 3, Lord.
In which order?
What's it? It's at page 14 of the IA, 27 to 26. Lordship, if the Lordship may see respondent number 5, 6, and 7, Lordship. It's Assam State Fertilizers and Company Limited. Lordship, it's actually Chemicals Limited. That is the small correction.
Where? In which order?
Lordship, of the IA, so page 14. Yes. If you notice, Lordship, in page 13, Lordship, if you see, respondent number 5, the managing director, Assam State Fertilizers Company Limited, Lordship, and Chemicals Limited. That is
The cost title.
the cost title. Same is enumerated in paragraph 3, Lordship.
So this correction is for 5, 6, 7.
That's it.
5, 6, 7. Anyone respondent?
We have served copy to Mr. Dhar.
Where is Mr. Dhar? Mr. Dhar. Standing counsel.
What it is? Government
Government advocate.
senior government, he was only there, Lordship.
Yes. That's right.
Copy, sir.
Any objection to the corrections ought to be made in the course title. But the council would not. I have respondent. 5, 6, and 7. So far as 5, 6, and 7, it's shown to be submits like this. Corporation,
Fertilizers and chemicals.
fertilizers and chemicals. It's in the same box. This is correctly reflected. Liberty. Permitted by amended title and title 567 as Assam State Fertilizers and Chemicals.
And chemicals.
Instead of elected title earlier as Assam State Fertilizers Company. correction be incorporated by filing amended statement. Correction in the respect of some state, but you like this. It's file before the
What's up, like?
yes.
Last of it,
Find it.
partial is, मतलब, judgment आया. Kobi Ramdas. मतलब Prem Singh also, मतलब.
No, but Yes. Under what provision? There is circular. Which judgment? Which judgment? Paragraph? Where is the circular? Is it available somewhere? Circular for the guideline which is there, is it reflected somewhere? Para 13. Where? No, it is reflected, but the where is the circular? Copy. Circular. Let us see. You are working as what?
But master rule work on मला
Master rule.
subsequently मला regularize as helper. Husband. After my husband died on मला 10/2/2006. Months after the date of regular.
Where is it mentioned that if there is if there is any shortfall, that will be counted for pension under the circular? Pension is the- You are referring to this Osubudari judgment. Para 13. Has to be some order passed by the authority. Circular only, circular doesn't say so.
Office memorandum page 25 मला. My
25.
25.
Second, on the government decision to regularize the service of the master workers of different government departments, government has been there for some time past.
No, this has been set aside.
No, my lord. Only, my lord, one clause, my lord, the period of master
6 years.
6 years.
That has been set aside.
That one. That is.
Ah.
Then I say,
Sanjita Roy.
I got 13. First position.
Para 13.
There are 30, 30.
30.
So it is held that deduction of 6 years from their services while calculating 20 years continuous service does not appear to be reasonable and fair as regards the decision of court rendered in the case of
And this is upheld by which judgment?
while of Binapani judgment.
Writ appeal number?
Writ appeal number, my lord, 18/21.
Sir?
For that, this is, my lord, (2021).
One, 6 and 7, Mr. B. Sharma for accountant. Then Mrs. Purva for spoken to. Serve as a master role worker, the executive action to have effect from 1/1/1986. Stop. Right. Subsequently, on 7/2005. Stop. Subsequently regulated. Serial number 107 in the list for regularization of master role workers for Gauhati Mechanical Division Department. While he was rendering service, it has been expired while rendering service on 10/2006, leaving behind the petitioner one unmarried. When the petitioner seeking family pension benefits, services rendered by respondents have not filed any counter affidavit. Instructions, the counsel for the respondent, Mr. White, submits that in terms of 140 of the some services pension rule, minimum period of 1 year. Ceased cover. Respect to the pension of pension. By the say judgments placed before the court. Respect of grant of regular pension. Some that by this memorandum dated 5/2009 had taken out a circular, this memorandum, wherein decision was taken past services rendered of the master role workers towards payment of pension slash TCRG. So, by the same notification, it's held, decided that after deduction of the initial period of 6 years, master role service, what balance period will be counted for grant of pension. Such period of service will be continuous and the incumbent was not broken period. Service was paid at monthly rates or daily rates. I will say OM, the Assam Services Pension 69, Assam Financial Rules and the Assam PW amended. Circular for 6 years. Bunch of pension. By the matter held that the deduction of period of 6 years from the services while calculating 20 years of continuous so the master rule once the requirement of 20 years of continuous service is satisfied by the concerned master rule worker, then that period, if required, can be counted towards the benefit of pension without any deduction. So, there are these different states. Determine number 8. That it's to the following that past services rendered in master role capacity prior to the regularization of master role work will become pensionary benefit. Actions ought to be made. Respect of final when they get rendered. By the mandatory service required for a government servant. Requirement for a government servant. They get master role worker. They regularize. Some regularize. Able to be counted. Like such master role worker. Otherwise, it's just about chill. which are already conferred by the plaintiffs will readily right on the customer workers have their services rendered in master capacity counted towards pensionary benefit. So then services rendered by the master capacity prior to the stop. Counting of past services is available run for pensionary benefits. Master pension there is no reason prime the family members such master worker the same government servant after the dies in harness. So better. Coming to the facts of the present case. Pensioner's husband after being right, 7/2005 died in harness on 10/2006. Thereby, there was the 6 months. Making the requirements of 1 year of in-person gets prescribed under such circumstances under the powers conferred that respondent year of the past effective year required counting past services to fill up stock of expire while rendering service after regularization. Regularized master loan worker
Helper.
as helper without completing a period of 1 year. Services rendered in master loan capacity. Right? That exercise be carried out as expeditiously as possible within a period of 6 months. Once. The date of receipt of a certificate.
All right.
File in a reply.
They have raised only 2 points, 142 and non-maintainability of registration. Yeah, argue, my lord.
But the affidavit has to be here.
Next week.
Mr. S. Biswas for the petitioner, Mr. B. Sharma for the accountant general submits that an affidavit has been filed yesterday, which however is not connected to the case report. Registry to trace out the affidavit file, and it's the matter hearing on 31st March. MSS Borwa for 1, 2, and 4. Please take on. Waiting for vetting.
My lord.
Waiting for vetting.
My lord.
Standing counsel, the accountant general. That is happening. So the file prays for how much time? Time. Prays for 3 weeks time. But after filing, they may like to file a reply, who knows? Then file it earlier.
File it by 31st, my lord.
You file it by 1st at least. 1st of April. Mr. P.K. Roy Chaudhary is based on 1st. And appears for the petitioner. Mr. S. Doctor for the respondent. This is the matter after 1 week. Weeks is paid for by Mr. S. Doctor. Mr. J. Hendick, department, prays for 3 weeks. Time to complete his instructions. Mr. P.P. Bhotakur appears for the petitioner. Very important past earlier. So 10th of April. After Bihu. 22nd of April.
One of the was supposed to file the affidavit, madam.
They have not filed.
Tag 1 and 2 together. Same cause of action, same issues involved in the matter. And the respondents were required to file affidavit both the matters together. Matter is selection of candidates to persons with disability, persons with benchmark disabilities. Although we have cleared the written exam.
Who appears for the respondent?
Mr. B. Gogoi had taken, on the last occasion, Mr. M. Guya had appeared on behalf of Mr. Gogoi.
Any counter affidavit to be filed, not filed. Mr. S.P. Thus appears the 1, 2. See?
206 of 2026. Next slide.
So, 2026. Selection and appointment. Benchmark represented by the standing counsel again. Affidavit filed with the state. Permit the state to file their affidavit, if so desired, and have the matter listed again. Fifth. Interim order, wherever passed, will continue till the next meeting. What matters interim order?
Yes, sir.
Wherever passed, step in.
Appointment has been made, madam. Appointment has been made for other candidates. We have been deprived, madam.
What is the interim order?
You have to keep one post. Madam.
Yes. For extra copy, Mr. Chakraborty. Mr. B. Chakraborty prays for accommodation to enable him to serve extra copies of the standing counsel for the respondent. Prays for a week's time, 2 weeks.
No, by Monday I'll give it. Even today also I can.
The matter stands deferred to be listed after 2 weeks, so that
Yes.
enabling the respondents in
Yes,
the meantime to obtain their instruction.
No, they are asked for a date, madam. After Bihu, madam.
After Bihu. Twenty-fourth of April.
Better, my lord, though we have challenged, my lord, that is 2 to 26 regarding the final gradation list of the DCA club already published, my lord, of the bets of 8890 only by depriving the petitioner's bets, there is 8991. In this regard, my lord, their affidavit is necessary, my lord. So, your lordship, in a shorter time frame, I am going to return by May, my lord. Enter may be hard,
To file the affidavit.
but the forest department, my lord,
Where is the forest department?
but now they are not. We go by appeared on last occasion, my lord. Their affidavit is necessary in this matter, my lord. So why they have, by depriving the petitioner's batch, only publish the batch of 8890 only? Why not 89 and 91 batch? This is the question involved. And moreover, my lord, the lordship will find NHF 14, wherein the composite when the gradation list of DCA published, my lord, at page 80, my lord. But without modification, withdrawal of this final gradation list, again, my lord, by depriving our batch, this 8890 batch only published, my lord. So we are agreed, my lord. No reason assigned, my lord. Already there is the final gradation list, my lord. After this honorable court order, my lord.
Heard, Mr.
Take it.
State is represented by the forest. Also, standing counsel forest. Yes. Are you filing anything? Mr. A. Chakraborty for respondent. B. Mr. T. for respondent.
APSC.
Where are you instructions?
I intend to maybe keep open, my lord.
Matter be listed again after 2 weeks. But the instructions are not forthcoming. Petitioner is at liberty to press, renew his prayer for interim.
Deep jobless.
This matter again 6th of April, 8th of April.
Yes, my lord. April.
We are fixing the matter on some date, take a date. 25th. Standing Council, item 1. 31, 32, Standing Council Health, represented by so and so. 33, 31 and 31 and 30. 31, Sir M. Goya, 33, MS Arbu.
But in this matter, the respondent side has filed an affidavit yesterday only. We need some time to file our affidavit.
How much time you require?
By 30th of March.
The counsel for the petitioner submits that of March. Submits that would like to file a rejoinder, the affidavit filed with the respondents. They have made allowed this again on on 25th. 25th. There is a caveat filed by you. It's the Proceeding Council, assisted by Ms. S. Musari, is for the caveat.
This is of Havildar clerks in the Assam Rifles. The of Havildar clerks in Assam Rifles. The advertisement panel is from page 14. Common advertisement for Havildar clerk and warrant officer. 128 vacancies, the reservation of SC, and CR. There is a note, my lord, in clause 1 of this advertisement that distribution of vacancies will be based on policy issued by the Ministry of Home Affairs. However, the state-wise distribution, or if there is any other distribution that is not mentioned in the advertisement, either as it may, my lord, the select list was published.
Now, readings are exchanged.
Readings are complete. But what I would be on, my lord, is that before different high, initially we had approached the Punjab and Haryana High Court. The High Court said that they don't have territorial jurisdiction naturally, so my lord. So therefore, we are before this ongoing. Now, my lord, before the Punjab and Haryana High Court, they had given a list of candidates who had been selected. Another candidate filed another writ petition in the Meghalaya High Court. There is a discrepancy in the names of the persons who have been selected. So what I would pray for, my lord, is if the records are called for about the selection, that would clarify matters. If I may just take lordship.
Have you added any of the?
My lord, we have made a statement that we are not on the selection of the persons. But if my lord comes to page 87, running page 87 of my additional affidavit.
What is the prayer here?
Prayer, my lord, consider that as that works. Lord, prayer is at page 11.
How many posts are there?
There were total 328 posts, my lord. 156 posts have been.
What is the status of the appointment?
My lord, 3 posts have been kept inside. I'm ordered this way. In respect of 3 posts.
you are challenging this ground that
I because though we had the written, the physical test and as well as the medical test, we have not been selected. They say in their affidavit that there are 4 vacancies. 4 persons, they say have been selected, but according to the affidavit itself, we see there are 6 persons. One they say is on compassionate appointment. However, that compassionate appointment, the person who has been selected, the select list is someone else. Why not comes to page 24? There is a person
to hear the matter. What
Why
else?
not? Why?
Why do you put the record?
Why not? Because of this. Why not comes to page
7.
87? This is the select list. Merit list. On that page, my lord. Why not you'll see at the first table list of selected candidates
87.
87. Annexure 1 of the edition. The first table, below the first row showing the column list of selected candidates. Lordship will see serial number 1 and 2. 3 and 4 are all right, my lord. 1 and 2, the ID numbers are 1217 and 9698. The names, my lord, Deepak Kharab and Sachin Nandan. Now, my lord may come to page 95. This is an order of the Meghalaya High Court, my lord, order dated 17/9/2020, in which the repetition of the other repetitioner there was dismissed. Starts at page 89, but I'll take lordship to page 95. There's a table reflected in the order itself. These are the persons whom they say have been selected in the Meghalaya High Court. Number 1 and 2 are Amit Kharab and Naveen. Their names are not there in the select list, my lord. So instead of 4, they say it's 4 vacancies. They have appointed 2 other persons in addition to another 2. They say they have to accommodate later. So 8 persons are being appointed. They say their vacancy is 4. Should sees the name at page 95, serial number 1, A and B. My lord.
All for the records, sir.
My lord.
Hearing.
This matter, my lord,
Yes.
deeply honest.
Right. After vacation. Yes, Mr.
After vacation.
After vacation. They need to wait. Third. 23rd.
Yes, please. Deeply obliged.
Confirms
The declarations have been placed.
like it's in mind.
Mr. Goswami, declarations have come. District and session judge some, and appointed to act as an arbitrator. Subject to furnishing of statement to this court by the respective parties. 16. That's it. Date when you want to approve. 7 March. 7 March. State. It's closed in terms of passport.
Pricing has been received from the direct arbitrator.
This whole arbitrate. Yes. 7 March. By the owner.
Series of rate petitions which I have filed. This is the challenging the impugn order passed by the scrutiny committee. Come to the impugn order done.
Yes. Page number. You're representing who? State. Why is this file here?
Yes. At the time of filing, I was serving at the
This is with regard to a termination.
not termination. Your Honor. This is with regard to the cancellation of civil threat certificate by the scrutiny.
Ah. Not in Arunachal.
But that certificate is here. Not the- Fine. Find that one. I mean, this is my pity. Because at the time when I entered into job, my certificate was the valid certificate and it was issued on the basis of an order passed by the state of Arunachal Pradesh, which I had annexed along with my petitions. Now, this is the findings of the scrutiny committee, not in accordance with the presidential order with regard to the list of scheduled tribes in respect of state of Arunachal Pradesh, because here they had always stated that the dairies are not in the list of the list of scheduled tribe in the state of Arunachal Pradesh, nor they had interpreted the list herein. Straightway they are saying that they are not. And moreover, they had mentioned a letter which is 11/9/2019 issued by the political assistant. Are they authorized to issue any such order saying that a particular community is not a scheduled tribe of a state?
Where is the list?
List, it's in page 161.
Sorry, Mr. Governor Advocate, what is it that you submitted?
Your here
Yes,
this,
yes. Rejoinder to the reply. You have filed your opposition. Then what rejoinder you want to file? One six one.
one sec-
What is
Yeah,
that?
right.
161.
because here detailed argument is required.
if he wants wish to file then a date fix for hearing, it starts with part 17, all the tribe in the state including. So this is an including list. This is not a conclusive list. So now first we need to see why this particular phrase has been inserted in the list. All the tribe in the state including.
No, you are referring to which page?
Page 161.
161.
161. It is filed by the state. The region. Annexure 4.
Is Deori mentioned here?
No, here it says all the tribe in the state. Now we need to understand what this phrase is for. Because all those tribes whose names mentioned, that is only as an example.
Where does one find the tribes which were listed on the date when notification is
So
there?
I will come to Your Honor when initially when the presidential order was issued in 6 September 1950. At that time, the present state of Arunachal Pradesh was a part of.
Was there a
Assam.
PIL or something with regard to this issue earlier?
No.
One, the Deoris are to be included in these tribes.
No. Here, inclusion doesn't arise. The phrase itself covers because I will come to the.
I don't know. From my recollection,
Yes.
I'm saying for the state of Arunachal to verify and apprise the
Apprise the court. Because
that there was a PIL when the issue was.
But there, all the contention was not decided. Even BN Lukur committee was constituted by the parliament. Even they had recommended that Deoris are the scheduled tribe of NEPA and then in 1965. So BN Lukur committee clearly defines this. When BN Lukur committee and even the Ministry of Tribal Affairs now and even till date, they are saying that Deoris scheduled tribe status, Deoris include as a scheduled tribe of state of Arunachal Pradesh because of that particular phase.
But you must come up with some authenticated official documents.
Yes, BN Lukur committee report is there, Your Honor.
But has it accepted? Is it accepted by the state? And necessary changes be made?
Because
it's a committee making a recommendation. It's to be accepted.
No. Here there is no any recommendation because the order based on which my certificate was cancelled was an order passed by a political officer, which is the confidential order. Can they issue a confidential order curtailing a scheduled tribe status to a particular community? That is the main questions here, Your Honor. Because they had referred this letter dated 11/9/2019, which I annexed with my petition. It's in page number.
No. Your claim is the basis of a certificate issued by the DC.
Which is the valid
This
certificate.
has been objected to by the committee.
No, they had objected. They are simply saying that since Deori community are not a scheduled tribe, but
Not a
without
scheduled
discussing the list of scheduled tribe in respect of state of Arunachal Pradesh. Because they have to interpret why that particular phrase had been inserted, all the tribes, and it's including. And on top of that, in even decadal sanctions, in everywhere, Deori community.
No. If you give a meaning of including all the tribes, it will include so many other tribes.
Yes, Your Honor. No,
Then
not all. Because
how can you be selective that all tribes, including so and so,
But
means all
no,
tribes
Your Honor.
which existed?
They should have a permanent residence there. Only all those communities who has a resident there, they can only claim citizenship at the time when.
They are citizens.
No, Your Honor. For scheduled tribe, it's respect of that particular state.
That's right.
Because
But they are otherwise citizens.
they are otherwise citizens. But here in this case, Deoris are residing in the state of Arunachal Pradesh before the constitution's order was notified.
Now, Mr. Counsel, you get that order of the division bench. It's in a PIL. Some order passed with regard to whether it was entertained, not entertained. I don't recollect, but there is an order. Your colleague must be aware.
Yes, Devanath,
You are aware?
I will get it.
There is one order, my lord, but regarding.
We don't know.
It was not finally decided.
We wanted to see that order if it is available. Find out.
It was reported in
97.
97 really.
Show us that. If
We
it
will
has
get
enough.
it. It is not available with us.
Huh?
So, can it get date be given because he also want to file a rejoinder.
Yes.
Because detailed hearing is required.
Matter may be listed for
Okay.
hearing, my lord.
Let him file what affidavits you want to file. State Council prays for a week's time to file an additional affidavit. Prayer made is allowed, not weeks, 2 weeks time, file an additional affidavit. But this will require, perhaps, it is better, the matter is posted before the higher and division, not division bench, Arunachal. Because you require all the documents and records. You have to go through the record every time. Take a call on the day.
Because this will, my lord, file because like booking here at India, now you are transferred to.
It's not on the locus issue, it's on the question of deciding this issue because we already have a bench in Arunachal Pradesh. Issue pertains to Arunachal Pradesh. It's concerned pertain to Arunachal Pradesh. Based on 9th. 9th of April. Yes, what happened here?
Arguments pertaining to order of 6/9/2024. Challenge before the Honorable Court. And that order came because there was a writ petition which was filed by this court 3900 of 2017. An order of 5/3/2024.
Now, what is the?
Now the question is that, my lord,
what
go
the
back.
state has done?
State has done nothing. Your lordship
They
has
are
said-
agreeable to revisit the orders.
Yes, yes. The order that has been passed by this court on 16th of February 2026. That indicates that the oral submission in re-verification can be done. But there is an election, assembly election, and they wanted some 2 months, 5 months time. How this can be managed? Election, the commissioner, they will not be busy. But whatever
This is an exercise which will
no,
require some
I
time.
am not saying that the exercise will not require some time. 4 months and this exercise can be carried. And apparently, my lord, their affidavit, it appears that no work has been, that the order that has been passed by this court has not been carried. Kindly see, their own affidavit says that it is 9/5/2025. This report is of 9/5/2025. So this report should be earlier. That cannot be after. And what they have done, when you have taken this point by reply, then they said, no, it is inadvertently there was a mistake. Mistake cannot be in one district. Mistake is made several of districts, same date, 9/5. 8/5, no, what? Please read it. 8/5/2025, 9/5/2025. And there are few districts where there is no date. Their admission, 16th of February 2026, kindly see that order passed by this court. They said that upon being permitted by the earlier order, that is 16th of February 2026 order,
upon being permitted by the earlier understanding of authority, so submitted an oral instruction.
Let us take up, say, page number 571.
Yes. Fine,
Submitted by the executive.
Yes. $571. Yes.
Because,
Right.
they say that out of after the advertisement, out of 216, 78 appeared,
Yes.
and those who appeared could not produce the relevant documents.
Correct.
Some were found to be doubtful.
Yes.
Records of such documents
Yes.
not available. What will be the
No,
effect of
what
sending it
now
back?
I'll say what they could have. No, what is the order that has passed? My lord, if they said that out of these 78 number of petitioners, certain document they could not produce, ultimately what they could have done, they could have given a notice to the petitioner, all these petitioners, this is what has happened. So we cannot take the matter into consideration. But they have not intimated as per the court's order. What they have done, this is our only grievance, my lord. 6/9/2024.
This fact was not intimated.
Not intimated. That's they have not carried. My lord, I don't. You take an action, but intimate to us.
What had directed that serve notice?
Your notice
Now
informed
the
us.
question is not done.
Yes.
By way of this affidavit, now you are aware that this is the order
My
passed.
lord, when this kindly see.
You are
My lord,
entitled to challenge this.
No, what I'm saying. No, there is, my lord, this is not done in pursuance of the court's order.
Where is the court's order?
Yes, please see the court's order. That order has been passed by this court on the second round at 530. Now see at 537, my lord. 536. 536, the last paragraph. 536. At this court has already observed report annexed to the additional affidavit. 2008, this court will consider that without entering into merit of the case, it would be interest of justice to dispose of all repetition by directing the responsible authorities in the water to have a re-verification with regard to the claim of the petitioner as to whether they were appointed so and so continuously been serving for 5 years. Now please see this last 3 lines. Let such exercise be done and completed within a period of 6 months from the date of receipt of certified copy and thereafter. On completion of this exercise, petitioner shall be intimated with regard to the outcome of such verification.
That's right.
So, they have done.
This outcome, let us say this outcome is what is reflected in 571, 571.
Yes.
Or 576 or any other.
Yes, yes.
Now, at best, you would have been notified with this, that this is the outcome of the inquiry. How does it?
What they have done is,
they're only supposed to intimate you with the outcome. You are at liberty to challenge.
No, our case is that you have not done any verification.
But that?
This is our case, my lord. These are made up case, my lord, that some verification carried away. Our whole case that you have not done any verification. These absolutely, when we came to this court and our whole case that no verification has been carried away.
If the state agrees that yes, we for a re-verification, if they say that no, we have undertaken verification, then we'll have to decide and pass an order.
What I'm saying, see, what ultimate, my lord, end of the day, if the verification, it appears that no verification has been carried away. So ultimately, as per the order, court's order, re-verification has to be done, my lord.
From the reports which are available at say on these 500 something,
yes,
there appears that something was done, some activity was undertaken in the form of verification. Now the particulars are not there. Whether this verification was actually done, not done, if done, then whether as per the rules, etc., will be a subject matter of challenge of this verification.
No,
Unless you maintain your, unless the court returns a finding on your arguments that there was no verification. Therefore, the earlier order remains. Alternatively, if the state is of the view that no, we will reconsider the claims and re-verify, then without going into the merits, we can dispose it of.
what I'm saying that I am not
But
saying.
if the court has
No,
to,
your lordship, there
if
are
we have to accept your
no, there are
submission,
two options here. Either your lordship enters into merit and says
we
this exercise are not done.
we
One.
will not on that. We will enter into merit. What we are saying is, it will require a finding that your submissions are correct, no verification was done.
That's what we are saying. That's
Then
what
we'll hear the
my
matter.
lord will kindly see at page 587. Kindly see 587 a reply. This is our specific stand. See 587.
Yes.
The paragraph, the second paragraph. On perusal, plain perusal summary of the executive engineer from various divisions, it is evident. Said report summary of various executive engineers from various divisions of Water Resources Department. Government of Assam was prepared recently in the month of May 2025. However, the input minutes of the meeting prepared by Chief Engineer Water Resources was on 6/9/2024. This shows at the time of consideration of the cases of the petitioner, pursuant to the order dated 5/3/2024, of this on no verification exercise was done by the department, and as such, nothing must communicate to petitioner regarding the verification exercise.
Well, then you
And what is there?
produce the records to show us what verification was undertaken. Produce it. You filed your affidavit.
Now, my lord, one last. My lord, please see 591. Their affidavit. Please see 591.
591.
Yes, their additional affidavit. Paragraph 3. That the deponent basically, as stated by petition paragraph 5 of the reply affidavit, the deponent like to clarify date and mentioned in the affidavit in the month of May was inadvertent mistake of the concerned executive engineer water for which verifications are given. Now, my lord, they have agreed. My lord, they have agreed that yes, we'll do a re-verification, but it requires some time. This is what my learned from the last occasion has agreed. That we'll do a verification.
But she's now done the whole phase.
That's my lord. If she comes today, tomorrow, it's a different.
If we have to remand it, then we have to be satisfied the verification was not done as per. Then you produce the record, let us verify it ourselves before we pass an order. Produce the records in respect of at least some of the verifications which are undertaken. Let us pass. No, see, you let us come to. Let us come at let us say 593. See 593. These are all self-declarations. These are by executive engineers. On which date? On which date? On which date? On which date? Same date, but which date? There's no date. And see what is stated there. That you had advertised and 15 numbers or 13 numbers or whatever numbers have appeared after examination by so and so. This is with regard to wrong mentioning of the dates, but you come to the earlier reports put up, appeared for re-verification, failed to produce any relevant document. What basis? I mean, see it from the perspective of the petitioners. There could always be a suspicion that this is not a correct statement. We had produced documents, they refused to accept. All records must reflect that who are the employees who were working earlier and what records are you maintaining. You not only have to produce the records, you have to properly even index as to which, in respect of which writ petitioner under which division, what are the records available in respect of the services rendered. Alternatively, if you agree that all right, we will revisit, you can close it. So manpower or no manpower, we'll see later. But now, you see, that would be self-defeating, because to say that there is no manpower would be, you have to give a description what was the quantity of manpower required for doing that verification, which you said you had already done earlier. What was the strength? Where are the records? Mere production will not do. You'll have to indicate, flag mark, give an index with regard to which petitioner, what records. Tell us what you wanted. 4 weeks, you say election is there and then you pray for 4 weeks. Yes, Mr. Das. Mr. D. Das, London City Council, assisted by Mr. Ivory. Council and Ms. P. Chakraborty, Standing Council Water Resources. So, asked earlier by the extension. Where is the earlier order?
5900. Fine. Start from 530. 530 for the operative portion of the order. Then
by order dated
536. 536 last one.
5/3/2024, passed in WPC 5823 of 21 and other bunch of petitions.
The
following direction was issued. What was 6, 7. There are pursuant thereto, it is the claim of the department that the verifications were undertaken and were sent up by the concerned executive. So, chief engineer. So, there are this claim of the department is strongly disputed by the petitioners in as much as Mr. Das has drawn attention to the attention of the board to some of the reports put up from different divisions where particulars in respect of the verification was discernible, and most of these reports have been submitted on 9/5/2025. So, Senior Council has also drawn attention to the portion that the verification decision thereof should be communicated, which also has not been done. Because the claim of the writ petitioner that petitioners There was some advertisement issued for verification.
There was some, he said.
He therefore submits that this writ petition be allowed, directing the respondents to re-verify the particular as State Commission. Finding that second 23rd April 23rd April.
Lord, I request your lordships to take up item number 49. Lord, I am praying for an interim order in this case. It's a very unfortunate case, my lord. The authorities have really acted arbitrarily. My lord, what had happened in this case, I'll just briefly indicate, my lord. I was aspiring to become an associate professor in oncology. I was denied consideration. I approached this on court. Learned single judge allowed my petition, but learned single judge gave me the relief prospective. I filed a writ appeal. I was allowed the benefit of retrospective consideration to the post of associate professor. Then, my lord, a review DPC said, and in that review DPC, what they did, my lord, they did not transfer me to associate professor. They even deprived me, stripped me of my assistant professor also. I was made the assistant registrar. I filed a writ petition, my lord, that was stayed.
Review DPC for what?
Review DPC for consideration of promotion to the grade of associate professor.
But they demoted.
Demoted me to registrar on the ground that I do not have the basic qualification. All these aspects were gone into, then only it was allowed. Then, my lord, what they did, they transferred me to Jorhat Medical College. Then I was transferred to Jorhat Medical College, my lord, in the orthopedics department. I belong to oncology. I had to again come and get a stay. From the date of transfer till date, my lord, we have not received the salary. From 1st of February 2025, I am without salary. Now, thereafter, my lord, I filed an IA. In the IA, there is a direction that I should be paid my salary. They have not paid. Then, my lord, they have issued a so-called notice and initiating a disciplinary proceeding. On the ground that, my lord, while prescribing, my lord, the medicine amongst others, my lord, I have asked a particular patient to get particular tests done in outside laboratory, private. Well, there was an inquiry where the so-called complainant was also present, we are also present. They said nothing, I have not complained. Now, my lord, this DP is going ahead. So I am praying for stay of this. Otherwise, my lord, when they do not follow court's order, when court says promote him to associate professor, they make me register, they are going to dismiss me, my lord. And whole thing is happening because a person, a very senior politician's, my lord, close relative, is the one who has, my lord, superseded. That is the only thing. A very strong politician's, my lord. Can the citizen be dealt like this? If your lordship would kindly come to the interim order, my lord, where lordship has
interim order passed on?
In this case only, Milord. Milord, order is dated 25/7/25. In this proceeding only, Milord, where Lordship issued notice.
Yes.
May I read it, Milord?
Yes.
The petitioner before this court is aggrieved by the fact that despite serving as assistant professor in oncology, his claim for promotion to the post of associate professor in the same department has not been considered. Consequently, petitioner approached this court by filing WPC number so and so, which was disposed of by the judgment and order dated 16/5/24. By the said judgment, respondent authorities were directed to promote petitioner to the post of associate professor oncology with effect from 9/9/14. It is the submission of the learned counsel for the petitioner that in an attempt to avoid compliance of the honorable court direction, the petitioner issued a transfer order to Dibrugarh. This transfer order challenged before this court in WPC number 1084 of 25, and by order dated 17/25, the said transfer order was stayed. This matter is currently pending final adjudication before this court. While the matter remains sub judice, respondent authorities have now issued a charge memo leveling charges against the petitioner and proposing panel under Rule 7. That apart, respondent authorities have also abolished the Department of Oncology and College. All other medical professionals and doctors working under oncology have been transferred to various other departments by order 13/6/25. However, the name of the petitioner does not appear in this transfer order, despite the fact that his earlier transfer order was stayed by an order of this court. Being aggrieved by this omission and circumstances, the present petition has been filed. Considering the submission made, let the notice be issued. And similar notice on interim prayer is fixed for hearing on 27/8/25. Respondents are directed to complete their instruction and file necessary affidavit. Well, just to show that, my lord, the lordship would kindly come to my lord page number 79. This is the show cause notice, my lord, which has been issued in this case, which is under challenge in the present case, page 79. Then my lord will kindly come to page 83. This is the so-called complaint, my lord, based on which, my lord, they have instituted this disciplinary proceeding. We have visited SCI today for the treatment of my father, Sri Khemraj Chetri. We consulted in room number 13, where first lady doctor saw the patient and then the male doctor, that is the petitioner, saw the patient, and he advised to get investigation alia wellness, stating that the investigation in SCI will take some time. So since we have financial issue, it is difficult to test outside. This is the complaint. Based on which, my lord, the complaint has been. Now then, my lord, I find this is the internal report, my lord. It starts at page 85. Now please come to page 86. Falsity of the, my lord, stand of the department, page 86. The concerned persons were called for hearing on 1/2/25 and their statements were received as follows. Gangaram Chetri, the complainant, Dr. Lohit Kumar Kolita, the petitioner. From the statements and available document, it is observed that patient Khemraj Chetri of Hingori, Ekiazuli, Funipur was referred by Tezpur Medical College to State Cancer Institute on 6th of October, as his condition was critical. The patient was admitted in the State Cancer Institute on the same day. Prior to his admission, required investigation as prescribed by attending Dr. Lohit Kolita were done in nearby private diagnostic clinic Alia Wellness Center at the cost of rupees so and so. He was admitted in SCI, State Cancer Institute, before receipt of the test report. Hence, it is clear that case could have been done in the hospital free of cost on priority basis under any government scheme. That is important. During the hearing, both the complainant and the doctor denied
that the doctor had advised attendant to get investigation done in private clinic. So this is the finding of the committee. Now thereafter, my lord, they are proceeding. My lord, what had happened? Now, my lord, in the disciplinary proceeding, my lord, I filed an application that I am not in good health, give me some time. Then what they do, my lord, they constitute a medical board, but they do not have time to comply the orders of this honorable court.
What is that order?
My lord,
Which order is not being complied?
which order, my lord?
You are saying orders of the court not complied.
Yes, number one, yes. Well, can we see what a scathing remark has been made, page 73, my lord. Please come to page 73. When the review selection committee, my lord, did not consider my case, then this was the observation of this honorable court. Page 73, para 26, last sentence. In view of the above, while the impugned action of the review selection committee board dated so and so and consequent order of the department has been set aside, respondent authorities are directed to immediately hold another review DPC to consider and promote the petitioner to rank of associate professor. Such promotion is required to be given effect from 9/9/2014 as directed by this court in the judgment and order dated 19/10/16 passed in WPC number 13/1395/2015. Consequently, all notional benefits including seniority and proper treatment are to be given to the petitioner in the rank of associate professor from the said date dated, that is 9/9/14. Now kindly see, the conduct of the department clearly appears to be unreasonable and vindictive, and as such, the aspect of imposing cost was also considered. However, this court has reluctantly decided not to impose cost. That, well, this order they have no time to comply with, but they have time to constitute a review DPC because, my lord, if your lordship sees my health,
But why we not proceed in contempt? You think that is
contempt is also item number 48.
48.
Yes. And my lord, and in item number 47, I am, my lord, where lordship has issued an order of direction for payment of salary. How can I survive, my lord? They want me to attend the proceeding without paying me salary. Even if subsistence allowance is not paid, court justifies not appearance in the disciplinary proceeding. And they have not paid my salary. IA 1462 of 25. Order dated 29/7/25. When this government would like to save somebody, my lord, they will pick him up from the mud. And they where they want to, my lord, I mean, send some good people, they will do also. Order is dated, my lord, 29/7/25. Paragraph 14, last sentence, my lord. Paragraph 14, last sentence. And after the comma, and in view of the fact that interim order still subsists and the writ petition is presently pending disposal, this court directs respondents to release the salary payable to the petitioner effective from the date it was withheld, that is 7/2/25. Until that, my lord, they have not paid my salary. How do I survive? Because I filed an application seeking time to, my lord, appear in the proceedings. My lord, they constitute the medical board. My lord, lordship knows the judgment in that prestige lights, where the Supreme Court had said that unless they pass with the contempt, they should not be heard. And they have a look at this, my lord, para 24. This what disciplinary proceeding? There's nothing. And have a look at para 24, my lord, at page 459. An order passed by a competent court, interim or final, para 24. An order passed by a competent court, interim or final, has to be obeyed without any reservation. If such order is disobeyed or not complied with, court may refuse the party violating such order to hearing on merits. We are not unmindful of the situation
that refusal to hear a party to the proceeding on merit is a drastic step, and such a serious penalty should not be imposed on him, except in grave and extraordinary situations. But sometimes such an action is needed in the larger interest of justice when a party obtaining interim relief intentionally and deliberately flouts such order by not abiding by the terms and conditions on which the relief is granted by the court in his favor. Well, I am not being paid salary. Court says consider my case for promotion. They demote me. Court interferes with that. Says giving. I kindly see from 2016 I am only filing writ petitions. From 2016 for the last 1 decade, my entire family life has been shattered.
Yes.
So my humble submission is, my lord, this disciplinary proceeding should be stayed.
That's my observation. There is no such thing. That is, you will have to participate. Unless it can be shown that without authority, that you have to participate if there is no merit, definitely it is exonerated from the charges. That's the whole issue,
Now, why is the subsistence allowance or salary not being?
No, salary.
Salary. Why is it not being?
Why? He is appearing for the last 10 years. He knows
I
everything.
don't have a display,
Some cases
I
you
can
remember
hear,
everything.
There is a cases there, remember everything. Now, so far as the expedition is concerned, both the disputes, all things are complete, lie has been filed, affidavit of opposition has been filed. I pray Lord may take up on the coming week, because
No, first tell us why the salary is not being paid.
The department of workers. That department has been abolished.
Then
The other challenge is the second expedition. Because as part of the regulations of the NLC, the department those that has been held by the petitioner. That is not there, So we have abolished it, and the department has been abolished.
That's why Cancer Institute has come up.
Well, basically, and that notification is under challenge in the present. Whether it is or not, speaking to that.
what we want to know is you have abolished the department.
Abolish the department.
Now what has happened?
There,
Huh?
No post there. That's the
No post is there. So what happens to the people who are working there?
Yes, they have been released and some have been transferred out, some have been given where the particular post is there as per the NLC. They have been detained. Documentary page 94 of the 4108. That's why I say, the transfer order is of February 2025. So it's hard, 1 year is enough, then everything will be paid, of course, but you have to regularize it. The department is not there. Page 94, pay election 12 of
What is there in 1084? 1084? State. You are transferred to Dibrugarh.
And to orthopedics. I'm an oncology man.
Now, 4108 is for
second case.
page number 94.
Compliance with the extent also order. The abolition of the Department of Gauhati Medical College of Hospitals with immediate effect. Consequent upon the abolition of the department, the nine section 4 under the Department of Oncology is then abolished. And the incumbents in those posts are hereby posted in post and department based on their qualifications and requirement as other person, my lord.
What is the
Like-
name of the petitioner?
He, otherwise, my lord, all telling me is here, but other so happen.
By this order,
Okay.
you have transferred the other persons.
No, no, transfer is already on challenge in the artist. February 2025 was transferred. During the pendency of this decree, came in. Because of the NNC norms, my lord. No, we have not done it, my lord. And my lord, it's not that, my lord, what you will see, my lord, the third parameter. MER 64714, that's 9, that's, my lord. That I want to point out. In the interest of public service, what is it? He has been, my lord, transferred out to Zoran Medical College. So, wherever, as per their, my lord, qualification, and he's the orthopedic surgeon, my lord. That is qualification. And all along the repetition to my lord, he has made a statement that he is an employee of the Gauhati Medical College. He was posted in Gauhati Medical College. So, from my lord, this medical college, he has transferred to Zoran Medical College. Possibility, my lord, page 8 of the repetition, my lord. The page 8, the last page, first para, last line. Pursuant there to the petitioner was appointed as registrar on college and posted at Gauhati Medical College and Hospital, Gauhati. Petitioner joined in the same course of in para 6. Same manner he has joined Gauhati Medical College. All along he has been making statements that he has. How transferred to Zoran? Manner things is substantive qualification is manner postgraduate in manner orthopedics. He has been now posted in the orthopedic department, and we in the academic we have stated that your team will not be affected. That is one of his manner apprehension. That is transferred out now. That will not be affected.
Yes, you are orthopedic.
Milord, my learned friend, I have a lot of respect for him, but he should not feign ignorance. My lord, these are the issues they raised in the very first writ petition, that I am not an oncology man. My lord will kindly take the other writ petition, my lord, 1084.
No, we are
No, what is it? No, in some cases, you have.
We are referring to your paragraph 2.
Yes,
in this writ petition.
Yes.
Where you said that you had obtained postgraduate in orthopedics.
Yes. No, my lord. Thereafter, my lord, I obtained necessary training and all, for which I was given the promotion. Those orders they have not challenged. They have attained finality. No, my lord, kindly come to the other writ petition. Just 1 minute, lord. Please come to page 30, my lord. My lord will kindly come to page 29.
Of this writ petition.
No, 1084. And all these aspects were gone into in the early first round of litigation, when they sought to deny me promotion on the ground that I am not an oncology man.
Page number?
Page 29 of 1084. On 21st of July 2008, 21st of June. Yes. Please come to serial 27 oncology, my lord. Registrar. 3 posts. Who can apply? MD medicine amongst others, ENT, MS orthopedics. Am I clear, my lord? Yes. Then my lord will kindly come to page number 30, the order of appointment after selection. Please come to page 94, my lord. Sorry, 31. Serial number 94.
Now, I'm just asking one thing.
Yes.
Is that abolition order under challenge?
Yes.
In the second writ petition?
Yes, I'll show, my lord. I'll come to that. Please come to serial 94, page 31. Page 31, serial 94. Lohit Kumar Kolita, Register Oncology. Now kindly see which serial number 95? Dr. Midul Kumar Sharma, because he has to be made professor. That is why everything is being done, Mila. And who is this Mr. Sharma? If necessary, we'll say who he is also. Anyway, now my lord will kindly come to that order which my learned friend has shown at page 94. Please come to that one. Yes. In the other writ petition, the order which my learned friend has referred. The abolition order, my lord. He was also appointed as Registrar Gauhati University as well as Midul Kumar Sharma. Kindly see, my lord,
Page number?
page 94 of the other writ petition, that is 4108. Now, abolition order. Kindly come to the first one. In the interest of public service and in view of abolition of department. Now, what is the date of this, my lord? This is date 13/6/25. In February, I was transferred. Now, my lord, why have you not sent him to ENT department of Jorhat Dibrugarh Medical College? He is a ENT man. He is not oncology man. No, no, that what you did for the last 10 years. You are defending this case. No, no, my lord, I am saying so. I am saying so because, my lord, an injustice has been done to this petitioner. You should not misuse your authority like this. Then kindly see, my lord, Aditya Chakraborty, he can be accommodated. Rupjyoti Bhattakur, it can be accommodated. Himanjyoti Burman has been accommodated. Arun Joy Roy has been accommodated. Why not the petitioner, my lord? Now, what is this disciplinary proceeding? That I have suggested to somebody that he should done few tests outside. And the inquiry report says, I have not said that. And on what basis they want to proceed, my lord? That's why, you know, there is a limit of harassing a person.
Where is the order of abolition?
That one, my lord. Page 94.
The order of abolition?
Yes. It's a pure and simple case where they have not followed the order of this honorable court with all impunity. And my learned friend is defending those actions. Had I been in his place, I would have said, first comply with that order.
Now the question is,
Yes.
not submitted
Yes.
from the respondent, that in view of the evolution of this department, these persons will get their salary from the places where they're posted. So far as the writ petitioner is concerned,
Yes.
he is transferred out, but it is under stay.
Understand.
So from where does he get his salary?
No, not how can I be sent to orthopedics? I'm not an orthopedics man. I'm an oncology man. Because this aspect was an issue in the first round of litigation. I was sought to be denied promotion in the department on the ground that I do not have qualification.
Your qualification is automatic, that is what you stated in paragraph.
I am not disputing that. But I also, everybody, similarly, my lord,
I understand that whatever automatic or whatever you achieved was as a rest, and you have all along been in the abolished, you are required to be sent to a corresponding oncology department, either in any hospital or in the state cancer or wherever. But it must be in oncology.
Yes.
You transfer me to orthopedics.
orthopedics.
That's okay.
Yes, that's. And my lord, my most humble submission is that they are not following the court's order, but they are doing certain things of their own, which amounts to, my lord, showing disrespect to the authority of this honorable court. In my humble submission, my lord, this
Court's order like that.
that, my lord, I should be, my review DPC should be held, my lord. I should be promoted to the rank of associate professor. That I should be paid my salary. My lord, that happened in February 2025. Abolition took place in July. My lord, it's a case, my lord, something has some supernatural power must have intervened. Otherwise, normally this does not happen.
What just thinking aloud for your benefit.
Yes.
That you receive the salary.
Salary.
What if the interim order is 55?
Yes.
Join your place of posting. Your prejudice claim. Department will give your salary. Then the other aspect of
What will happen to my promotion from 9/9/2014?
that we will examine.
No, that already order is there. That order is not, that need not be adjudicated.
No.
That is already there.
Promotion stop associate.
Yes, yes. With effect from 9/9/14. There is no appeal against that order.
You are now transferred. You now transferred where?
Dibrugarh.
Dibrugarh.
In orthopedics. Sorry, Jorhat.
In what capacity?
Assistant professor.
No, but he has been
Page 75 is the order.
directed to be promoted.
Yes. Send me on promotion.
But regarding the department page 174, what can you?
And which repetition?
My lord, this order is very important. For a moment, my lord. Please come to page 75 of the 4108.
410.
Yes, the order by which I was transferred. This is again, my lord, an attempt to overreach this honorable court's order. Pending receipt of report of the expert committee. This was in February 25. Pending receipt of report of the expert committee constituted to facilitate compliance of the order of the Honorable Gauhati High Court in WPC number so-and-so to read petitions for holding review PPC for promotion of incumbent and in larger public interest. Dr. Lohit Kumar Kolita, Assistant Professor, Department of Oncology, attached to State Cancer Institute, GMC, is hereby transferred and posted as Assistant Professor, Department of Orthopedic, Jorat Medical College, in place of so-and-so Assistant Professor. How can I go as an Assistant Professor, my lord? And where is the scope to constitute an expert committee? Court has given a judgment to promote me.
Where is that judgment?
Yes. Yes. That judgment, my lord, at page number 61. And operative portion is at 74. Just one page before that. Judgment is dated, my lord, 16/5/24.
Yes.
Please come to 73, my lord. Last sentence at para 26. In view of the above, while the impugned action of the review selection board and consequent order dated 2/4/18 of the department has been set aside, respondent authorities are directed to immediately hold another review DPC to consider and promote the petitioner to the rank of associate professor. Such promotion is required to be given effect from 9/9/14 as directed. This court in its judgment and order dated 19/8/16 passed in WPC number so-and-so. Consequently, all notional benefit, including seniority, proper fitment, are to be given to the petitioner in the rank of associate professor.
This is the clear direction.
Clear direction.
The clear direction.
Here is a case when not even kindly consider. Cases, one is regarding the transfer, other is the third thing, and the abolition of the part. These are the three. But that promotion part, there is an order, they preferred a concept. That will be educated in the concept of well, so far the transfer part is concerned, not to make kindly see, well, February 2025, the transfer is we have been with both parties, I would say, well, there's been saying fix the manner for final disposal. And not even well consider this melody. If we are wrong, not even if we are other melody. Yeah, apple melody. Transfer method of specified department has been able. We have been repeatedly stating in the affidavit, ground affidavit that it will not be affected by.
That's all right. But
That
what
part,
about the direction to set up a review DPC and whole?
That part, I will have the instruction of that. But one is the major issue they have. But there is a pending there that can be done now.
You don't know that price and that under such and such.
All the instructions I did Tuesday or Thursday, I did very short issue, these are whatever we have stated today, the same will be read at the time of
this is a judgment of 2024. DP was initiated in July.
and that
25.
So clear is there, more so far as this I pick my
What is your ground for challenge the abolition?
My lord,
The ground for challenge?
malafide, malice in law. No, my lord, abolition is a prerogative of the government. If government wants to abolish a post, their citizens do not have any right. When it comes to creation and abolition of post, they have absolute discretion. You have accommodated everybody, others. I am a cancer man. There is a state cancer institute. You post me there. Why are you sending me to orthopedics?
Essentially, you are affected by the posting.
Yes, posting.
Essentially, not by the abolition.
Yes. Well, abolition will not affect me because otherwise, even in spite of the abolition, they can still avail my services. There is not a single blemish in my entire career. Yes.
That this abolition is not the guidelines or any government.
But that we have not said.
That is not said.
Our case is, it's a malafide.
Abolition,
Malice in law. Yes.
But consider my specialization.
Yes.
Mostly my specialty.
Yes.
That's your case.
That's my case. Why should I go
And
to a
your
department?
dispute is with the other gentlemen who were not allowed.
He was junior to me, Mr. Sharma. He was junior to me. He was junior to me as a registrar. Now he is above me. He's a professor now.
Now, in that view of the matter, you still agree
Yes.
with the fact that
Yes.
in the interim, as I can see, is to modify the interim order, allow joining in case of directly back without prejudice to your claim.
No, my lord.
There
That
in
will
the
be again a double punishment for me, my lord. Kindly say, my lord. End of the day, for the last decade.
Then we'll have to hear the matter. We'll have to
Yes, my lord.
wait until the matter is heard.
And my lord, my learned friend knows this case in and out. From 16 onwards, he is appearing, my lord. Now, every time he will take up this plea, my lord. Only thing is, my lord,
17, my lord, next week. Yeah, my lord.
only thing is, my lord, they will not take any coercive measure during this period. Here's the matter.
That is state.
Because they have instituted a, my lord, a medical board, whether I am fit or not, to attend DP. They do not have time to pay me salary. They do not have time to hold review DPC, but they have time to hold, my lord, medical board. If these are not malice in law, what else is, my lord? Kindly see, a person is suffering for 1 decade and he has a special child, no money. Very unfortunate, my lord. Why he should file all so many cases?
But the problem is that to get your salary, you must go and join a posting.
What I'm
which is
saying
under
is,
state.
my lord,
In view of the fact,
if they give me a posting, I'm not saying that I should be retained in Gauhati Medical College for all time to come. That is not my case either. But you should not.
We are concerned with the fact.
Yes.
At the first place, your salary has to
Yes.
and you're not under suspension.
Not under suspension.
Therefore, salary area, whatever is complete.
Yes.
But it must be considered head of account. Now, the posting which is working, that entire department, etc., everything is you are now transferred to.
No, that happened prior. That transfer was prior to the abolition.
Right. But now.
Now, the post-abolition, my lord, they have accommodated other people. Other people are getting salary.
That will be the outcome of the final order. But in that
no,
order,
I'm not asking for salary today. All that I'm saying is, my lord.
Then we'll hear the matter.
No, what I'm saying is, let them not take any coercive measure or in respect of the disciplinary proceeding till the next week. Because they will hold the inquiry proceeding and dismiss me, to get rid of me. It's a very ruthless people. These are all. I do not have any compassion.
What is the stage of the discipline?
And they have invited us to inspect documents. No, there is no bar, but there is also no bar to reinstate me. There is also no bar to hold the review DPC.
Departmental proceedings are under challenge.
Yes, in this case. That's why Lordship issued notice on the interim prayer. Yes, charge sheet in DP. That's why Lordship has issued notice on the interim prayer.
Mr. K. N. Chaudhary, Learned Senior Counsel, assisted by Mr. J. Patwari, petitioner, Mr. State. Readings are complete?
Yes.
Readings are complete. The matters will have to be heard. Yes. The date?
Yes.
April. In April.
My lord,
there are matters already. Dockets are already.
Let it be on 7th, my lord, if it is not otherwise, or maybe 21st.
No, my lord. Or my lord,
7th.
26.
No. Let it be 7th, my lord.
We can give you a date on 2nd if you are agreeable.
Okay. Okay, man.
2nd of April. That's all then.
They will not take any coercive measure in the DP. No, why should I participate? You should also have some compassion. Why? And
Let,
if you, having seen the facts,
since the departmental proceedings are under challenge, that till the next date fixed. Measures be taken against the writ petitioner in respect of the same. Till the next date fixed. Endeavor will be made to dispose of the writ petition on the next date.
and the earlier order, interim order will continue.
Earlier interim orders wherever passed will continue. These matters along with the contempt.
Deeply.
Chip, I'm appearing on behalf of Mr. Chanya. He was in Delhi and supposed to come today morning. Flight got delayed.
Matter stands deferred on the request made by the council for the petitioner. 25th, Mr. Chakraborty appears for the respondent.
At the importance of when the pensioner benefit.
What happened in the mediation?
Mediation, there is nothing.
Failed. Failed.
Yes.
Who's for the respondent? Rima Hasan. Yes. What have you to state with regard to pension? Readings are complete.
Yes, they have filed affidavit. We have also filed.
Matter be listed on 2nd of
Possible in the month of March.
Already 15th, 31st of March. 31st of March.
Already.
Counsel for the petitioner submits that
However, last time, like to say that in case any cause of action survives,
the petition become the petitioner is not inclined to pursue the matter. No instructions have been furnished to the council in spite of repeated requests. Accordingly, the petition stands closed. It is not pressed interim order. The hearing stands pending item also dismissed. Mr. Ranpi appeals for the sorry, for Karbi Anglong, the Autonomous Council, Mr. Monto for 11-12, Mr. Yazorika for respondent 6, Mr. Chakraborty, appeals for the state respondents. Needless to say, if any cause of action still survives, petitioner is given.
Then on the last occasion, the look was directed to obtain instruction, and as well as the ASM.
Any
So the
instructions?
petitioner here become the 64 years of ASM. Well, what?
Yes, BTC. Is finance a party?
Yes, yeah, fine.
They have sanctioned the amount. Where is the sanction order? 45, you sanctioned it.
45, 46, 47.
Just send to the Women and Child Department. Who's there for Women and Child? What is 1 and 2? Women and Child. So get your instructions. What has happened to the sanctions? Ms. N. Chaudhary, Learned Standing Council, BTC, submits that by communication dated 29th of April 2025, no, this is what, page number 51, 6th of December. Communication dated 6th of December. The issued by the Joint Director come CHD, Women and Child Development, BTC. Respective amounts towards death cum retirement gratuity is sanctioned. Stop. It is expected that these communication have already been forwarded to the Office of the Accountant General. You verify it, you take a, you verify it. No. You verify whether pursuant. You have not received. Okay. For the council appearing for Accountant General and Finance Department submits that no such communication received. Stop accordingly. The Standing Council by the next date will apprise the court as to status of these communications shown to have been issued by the Joint Director of CHD, Women and Child Development, BTC. Stop. This matter again on 30 March. BTC is already a party. They have already filed their affidavit. Based on 30 March 30.
The respondent number 7 and 9.